Mm. And we try again. Can we do a test and see?
Test 1, 2, 3. Test. Test 1, 2, 3. Test. No echo. Okay. All right. Now can the folks online hear?
Yes.
There's a thumbs up.
Okay. All right, we can hear. Okay. All right. Did they hear any of the introduction? You believe not? Okay, thank you for that. Okay. All right. So let's just quickly just kind of restart. Okay. All right. Thank everyone for being here this morning. We see that we have 3 of our great commissioners with us. One in live and living color, Commissioner Tibbs. We see our chair and our vice chair. So at this time, I would like to turn over the mic to our chairman, presiding officer, Larry Allen, to provide any welcoming comments to us this morning. Mr. Chairman. Okay. All right. I see his mic is on. Okay. Vice Chair Sapansky.
Yes, sir. Good morning.
Yes.
Just want to thank everybody for being here. I'm excited about this stakeholders meeting and just appreciate everybody taking time to get on the call and for all of your input. So look forward to the meeting. Thank you.
Okay. Thank you, Mr. Vice Chair. Chairman Allen, your mic, we're showing your mic is on.
Well, I don't know if it's working, is it working or not.
We hear you beautifully.
Okay, thank you very much. Let me echo the vice chair's comments as we continue to review and take your input as further looking at different areas of our rules. So Mr. White, go ahead and continue, and I thank you for leading us.
Yes, and on behalf of everyone, we thank our staff that's with us. Before I get into that, Commissioner Tibbs, you want to?
Well, good morning, everyone that's here again, and good morning to everyone online. Thank you for joining us. Your input is so important, and just remember, this is your meeting. We want to hear from everyone and know what you think and what you're hearing from the consumers so we can do the best possible work for the Texans that we serve. So thank you all for being here, and thank you to Mr. White and your staff. You all have done a great job getting us where we are. So thank you.
Thank you, commissioners. Again, the staff that's with us this morning for resource purposes is Ms. Sparks with our legal department. Thank you, Ms. Sparks. Mr. Bass with inspections. Thank you, my friend. Ms. Rodriguez with enforcement. And Ms. Maria Haynes with licensing, and they're here for us for resource and context as we work our way through these proposals. Our staff attorney, Sarah Hartsville, is with us as well, and obviously she will have a lot to say. And so we will begin with her with providing us a context about Texas rulemaking and some of the other aspects we keep in the back of our minds when we're helping you out on rules. Ms. Hartsville, the floor is yours now.
Thank you, sir. All right, good morning. So again, just real quick recap, and y'all might have been able to tell from the website. So right now we're doing 2 different sets of rules. We're doing rules according to our quadrennial rule review, and then rules to implement new statutes that were passed this last legislative session. Per state statute that governs the agency, we are required to get feedback from stakeholders, which I think is good because y'all are the boots on the ground. We want to know how things are affecting you in real life. And so this is kind of where we're at in some of these proposals. per state statute, there are certain procedures we have to follow as an agency anytime we propose new rules. So a lot that goes into that is not just the proposed language, but we have to look at how that's going to fiscally impact local and state government, any public costs or benefits to the rule. We have to see if it's also going to require the agency to have to bring on more people. So there's just a lot that, and whether it's going to affect rural communities, small businesses, a lot of that, or if there's going to be a barrier to market entry. So just know that anytime we propose a rule, we have to look at all of that as we move forward. So once we do have proposed language together on a rule, we have to publish that with the Texas Register, which is through the Secretary of State's office. State law requires that be open for 30 days for public comment, so that once it's posted, any member of the public can submit comments to us on maybe strengths or concerns that they have with the proposed rule. And then the agency will take time to look through those, maybe make changes based on that, maybe not. Depends on how much feedback we get. And then once all of that is together, it will go before the commission for adoption. The commission will review it and vote on it. If they adopt it, then the rule is eligible to be effective in 20 days after that meeting. That's the earliest it can be, and then but the commission can't wait on it longer than 6 months. So it's like a time frame from anywhere from 20 days to be in effect for 6 months. And again, that has to be filed with the Texas Register. So from my understanding, if it's not filed with Texas Register, it doesn't go into effect. So that's kind of like the sum of what we're doing. There are procedures in place for an emergency rule, but I don't think anything we're doing is going to require that, so I'm not going to go through that. But just so you know, that's kind of what we're going through right now. So this is kind of like the initial stage of all that.
Okay, thank you so much for that. And so obviously this is stakeholders. We will bring these proposals up. We'll take your recommendations and your concerns, and what is likely to happen if we move forward with rules, okay, is when it gets to our commissioners, they will see where we started, probably in a stakeholder meeting as a proposal, how the language changed, maybe in the stakeholder meeting that's considering these rule changes, and then the subsequent draft based on your recommendations, so the commissioners can get a fact pattern of how things changed if they did throughout the process. So let's, can we just go ahead and start with our military license rule? Okay, you can go ahead and yes, and we'll go ahead and get this up. This is due to two pieces of legislation, state and federal, dealing with military spouses, service members, and veterans. And we'll go ahead and get that up. Ms. Hartsfield and the entire staff have done yeoman work in getting this draft up. And we're going to get it on the screen here. There it is right there. Lord, yeah. Okay. And we have it up there for. Okay. We'll get it up here. Okay. And we want to just take them through all of it. Yeah. Okay. Do they see it? Okay. You are screen sharing. Okay, good. So that's our first one here. It's several pages. Okay. This is probably the closest any rule is going to look before it gets over, definitely before it gets before our commissioners, then gets over to the governor's office. And if it makes it through those two, then over to the rulemaking. So turn the floor over to Ms. Hartsfield to discuss the language.
Sure. So the first, I think 6 pages you'll see is kind of what we are required to put as a preamble to a new rule. It's kind of some of the things I was explaining earlier, just about the fiscal impact. We are required to do a section by section summary, so that is kind of up there. This will probably be the longest preamble rule you'll see, just because there were quite a few substantive changes to not only implement the rules, but also update to be consistent with current statute. So if you'll scroll down to, well, I'm trying to think about the best way to go through this. Page 7 is where the language starts. Bottom line, what we're doing is moving everything into its own subchapter, so that under the licensing requirements, there's just one place that if you were a military service member, or you are a military service member, you're a military veteran or military spouse, there's one place in our rules that you need to go to find everything that applies to you. So that's why there's some of it was already in rule already. We just kind of all over. So this is just to kind of streamline everything. Not just military, but also with our reciprocal licensees, it does require that if you're from another state, if you have a license from another jurisdiction that has substantially equivalent requirements, then a certain licensing procedure applies to you. So in order to kind of help establish a process for how the commission will determine if another jurisdiction has substantially equivalent requirements, that's what this new Rule 203.2 is. We are repealing the current 203.2 because that's our current military licensing rule. But since we're creating a whole new subchapter, that's why we're repealing that and implementing this new rule of what substantially equivalent license requirements are. So kind of in that, do you want me to give them time to read it?
You can
Okay.
give me time to check
Y'all
it
want to,
out.
I don't know, y'all tell me, would y'all like just time to look through that? And it kind of goes through what we as the commission would be considering to determine whether a state has substantially equivalent licensing requirements.
And if we were doing a summary of this, first of all, we have been directed by Senate Bill 422 to come up with this language. There's also been federal legislation that has required us to revise this language. And what the summary, my friends, is this kind of catches up and this is going on all over the country because of the federal legislation. This is to catch us up with some of the new concerns about when spouses get a divorce, okay, and they're military spouse and they get a divorce from the military service member who is on active duty. And, we know there are provisions that are in law now about your health insurance when you separate or you get a divorce. It's kind of to catch us up with those times in the military licensing frame. Also, we would say this rule catches our commission up with previous statutes since 2013 and 2015 as far as evaluating veterans' military service as it relates to the requirements to get a license. Okay, so for example, and I think this would probably happen maybe once every 5 or 10 years. Okay, where someone from the Navy, the Air Force, the Coast Guard, the New Space Force, the Army, the Marine Corps, they were in mortuary affairs or in bombing services, and they want to come to Texas, or they're from Texas and they want to come back home, and how that military training experience would relate over to licensing. So this rule does that as well. If you look at current rule, like in 203.1, that's the general rule for licensing. You've got a reinstatement piece in current rule now for our veteran service members and spouses. who are reinstating. Then when you probably jump over to 23.056 and 7 in the provisional rules, there's something over there dealing with it. What we intend to do in this situation is bring all of those provisions and rules that deal with military licensing in one rule, the 203.2. That's the military rule. Bring it all there. So it's all there. It's neat. It's clean. And our licensing staff can enforce the rule with the regulated community with simplicity and consistency as well. Yes, sir.
On number one, educational requirements.
Yes.
That does encompass the requirement to graduate from an accredited program.
Determining
yes,
what substantially equivalent would be, yes, like if they have, like, let's say, I've been using New Jersey as an example, I don't know what New Jersey requirements are, but let's just say they do require a graduation from mortuary law school, then yes, then we would count that as, okay, then they have a similar education requirement to what Texas does. Maybe they also have a apprenticeship program, they're like, okay, then they're similar to that too, like just kind of knowing what we require as Texas and comparing how close other jurisdictions are to what Texas requires, then that would help determine whether it's substantially equivalent.
But some program would have to been completed, because like California doesn't require
So,
anything for a funeral director.
right, so that's why I was saying, like, there's two different avenues, like, we're not changing that. So there's like an avenue A, like if you, similar to our reciprocal, because like right now, if you're reciprocating from a substantially similar state, you go through part A. If the jurisdiction is not substantially similar, you go through part B. Same thing with this is, and this is kind of where federal and state law, we'll get into it later. There are some, like Texas requires you to have, like for certain out-of-state reciprocity for military, veterans, active service members, spouses. If it's from a substantially similar jurisdiction, there's option A that you go through. But federal law just says they just have to be licensed as a funeral director. Federal law does not require it to be substantially similar. However, federal law has an extra requirement that we don't require as a state. So that's why there's an option B, that if you're not similar, then you're going to go through this second avenue. So by both state and federal law, we have to comply with that. So that's why we're going to have, and that I will go through that more detail later. But this is just so y'all know, this is how we are determining which jurisdictions have a substantially similar licensure program to Texas to determine which license option they're going to go through.
Which part of the rule are you
Well, I'm just, in reading through this, nothing ever mentioned the mortuary completion.
Yes.
So I just want to make sure that there are numerous states that don't have requirement. It's on the job training and they get a license. And it's a lot of military states, California being the biggest. So just if they come in here, we want to make sure they have the education requirements and not able to just walk in and perform duties and directors.
And they'd be required to do like a mortuary, like Texas law exam, or like just even something, because it just gets scary that someone could just, oh, let's move to Texas, I'll get a job.
We need to just go through the whole thing, because I think some of y'all's questions are gonna be answered as you see how it all fits together. So let me do this. Maria, let's go back up to page 2 and we'll go by the section by section summary, and then we'll dive into like the more like the deeper language. Just so you can kind of see the big picture overall, and then we'll dive in. I think it's page 2. Hold on. Yeah, or I'm sorry, it starts on page 1. At the bottom of page 1. Okay, so, no, you're good. I'm just gonna kind of describe. So, before we get to the meat of the change in military licensing, we had to do some like cleanup administrative in order to move to the meat. So that's more of what that 203.2 is, because we previously did not have it. And again, the reason we had to include that is because of the new bill, Senate Bill 422 has language in there about if someone meets if they have a license from a substantially similar jurisdiction, then they are allowed to be like certain licensing requirements can be waived. So that's why we have to be able to determine, well, what jurisdictions are substantially similar to Texas. So that's why we put that in there. So y'all, again, so everyone knows this is how we're making that decision. But again, that's where we want feedback, is if you think anything should be added, changed, revised. We need to know that so we can consider that.
And just so how this looks in the office, if you're Ms. Haynes or one of our licensed clerks, or myself right now, when a reciprocal comes to us, first decisions I want to look at is, are they reciprocating or coming from a state? And this is not necessarily military. Okay, this is just everybody, right? Or are they coming from a state that has substantially similar requirements as Texas? So that would be, have to be at least 18 and over to even step up to the table and apply. You have to have graduated from high school. You have to eventually graduate from an accredited mortuary school. So even if they say, I graduated from ABC mortuary school, we're going to still look at the ABFSC to see if it's accredited. Okay. They must successfully pass at a 75, the mortuary law exam. They must successfully pass the national board exam, proving competency with 75 plus. And in the course of them doing their work in the other state toward full licensure, they completed a provisional or apprentice program. So the idea that they've checked out on all those, we say, okay, you are coming over from a state or other jurisdiction, excuse me, that's substantially similar. In that instance, we're able to pick up that application. And if you have served as a licensee in good standing, because then we ask for a license verification from them. And if they've done that for at least 1 year in that jurisdiction, we can move forward with licensing. Okay, so that would be substantially similar. Now, obviously, we do get applicants, and she's about to go into that may come from jurisdictions that are not substantially similar, and there's a route there. Go ahead.
Sure. Also, just real quick, I've noticed I had a couple of grammatical errors, so just know, just some of it, I was working really late on the slide, so just disregard any grammatical stuff. But okay, so moving from substantially equivalent, now we're diving into the new subchapter we're creating for our military licensees. And so that will be that next section of which describes subchapter D. The first new actual rule 203.55 basically describes what legal basis we have for doing this rule. So that's primarily in Texas Occupations Code, chapter 55. And then we have a specific statute. I'll probably reference it later on. It's 651. Oh, it's what we're currently operating under to waive all license fees for active service members who are currently on duty. So we're making sure that stays in place. And then the other one is, and y'all will have it and you can look it up later, but the federal law that we've been referencing is 50 U.S. Code section 4025, small letter A. And basically it's what Mr. White was referring to about federal law is requiring us to expedite recognizing out-of-state licenses for military service members and their spouses. Okay, so again, because we're creating this new subchapter and because lawyers love definitions, we've created a definition stage just to make sure it's very clear who this new subchapter applies to, who it doesn't apply to, that kind of thing. Okay, 203.57. This is incorporating, I believe it's incorporating kind of like what we already have in different sections right now in our rules, but just putting it on one place about exempting military service members from late fees or getting an administrative penalty because if they were on active duty, and that's the reason why they couldn't renew their license. Obviously, we're going to extend grace for that. They will have to prove that they were on military duty, not just saying it so that we're not being frauded, but so that's what that 203.57 is. 203.58, and a similar thing if if military members are on active duty, when their license expires, they're gonna have an additional 2 years after being discharged to complete continuing education requirements or any other license renewal. And that, again, like some of the stuff has been in statute for a while. We've just not had rules in place to,
I have a question
yes, sir.
in regards to the education of the military.
Mhm.
Does the military member also have to have graduated from an accredited mortuary college?
It depends on which avenue they're going under. So that's what we're gonna get down just a little bit later,
Okay.
because there's different parts. And again, part of what we're including is based on what we are expressly directed by statute to comply with.
Yeah, I think statute says you have to be a graduate of an accredited mortuary college.
Not under the military, the occupation.
No, I'm
of the
saying-
military.
In the occupations code, it
16.
says that you have to be a graduate of an accredited mortuary college. That's what I'm saying.
If you're applying,
Civilian.
Yes, so
but for the military, so the military underlying statute is also in Texas Occupations Code, and it's chapter 55. And in that, there are phrases saying notwithstanding any other law, meaning no matter what other laws out there, it trumps that law and what can be required. And so, but that's where the substantially similar come into effect, because
Yeah.
we're not gonna let just any Joe Blow take
Right,
advantage of that. We're gonna make sure they truly are qualified.
right.
And so we'll kind of go through, because it is an extensive like verification process of what they're showing. So can I answer that now, and then anytime we'll readdress it as we go more detail?
Thank
Okay,
you.
yes, sir. Okay, so. Okay, the next one, the 203.59. This is where we kind of set the standard, and that's kind of what Mr. Robbins was addressing. So under chapter 651, there is a standard of what license or applicants have to meet in order to get licensed. So we set forth what that standard is, so that we know that as we're moving to the military, if we're saying that we're crediting towards that standard, that's what that is. So that 203.59 will elaborate on that when we get further down. And again, we'll look at all the specific language. Okay, so the next 4 rules are implementing several different sections of code for chapter 55. This is where I wish I had a marker board. So, okay, so under our current rules, we addressed 2 of them, but we did not address a statute that was in place. And so we're kind of updating all of that. So, okay, I don't know what the Zoom people are saying, but, okay. So section 55.004. And so this is going to cover, well, before I go there, rule 203.60 is basically saying any military service member or veteran, not military spouses. So this only applies to members or veterans who have shown like that they have military experience, service, training, or education in this like industry, or where it would count towards where we believe it would qualify. Then the commission can count all of that towards the licensing requirements for those individuals. This is, I really wish I had a marker board. So this is kind of like the overarching law. So it applies to any military member or veteran. So we'll walk down through what that looks like, because that also includes counting it towards the provisional licensing requirements. But then we move over here. And this is kind of like what we have in current rule that we're streamlining, is if you have a out-of-state license from another jurisdiction that's substantially similar, or you have the same exact license in Texas from 5 years ago, but it expired, then you can have your license expedited by these avenues. and this is kind of where it gets confusing and it
You're
may just
getting
get
there.
easier
I'm
to learn.
following.
Okay. So,
Keep that board going.
okay. It took me a while to like really understand how all of these work together, just so you know. So if y'all are following, you're doing a lot better than I am. So we clarified what that's going to be because there are the substantially equivalent in 5 years, this not just applies to military members, veterans, but it also applies to military spouses. And there's certain things I believe that can be waived here, maybe like fees that aren't necessarily over here or vice versa. Don't quote me when we get to the rules. We'll see all that because I had to double check statute and everything to make sure I was doing it correctly. Okay, so that's that. Then what the other thing is now with this new federal law and House or Senate Bill 422 for military spouses. The new law is expanding it to military members about if they also have an out-of-state license. And this is where it gets to the two-part difference of if it's substantially similar, then we have to expedite it within 30 days of receiving that application, of reviewing, processing, and approving. Or if we don't think they meet the qualifications, letting them know that we don't approve and here's why. But if for federal law, as long as the military member or spouse has a funeral director or embalmer license, and federal law doesn't say they have to be substantially similar, just as long as you have a funeral director or embalmer license, we as the commission are required to honor that if the person was actively practicing in that license the last 2 years before applying with Texas, they're in good standing. They provide us with a copy of the military orders because this one is, this third option is only for the period of time which the military service member or spouse are stationed in Texas. And it can only be for as long as they are stationed in Texas. And it can't be renewed. So it's like a one-time non-renewed authorization for them to be here. Under state law, the max that can be is 3 years. Federal law, it doesn't give a cap, it just says for as long as they're stationed here. But again, we have to be provided proof of the military orders showing that they have to be stationed here. So those are kind of like the three
All this
avenues
boiled down.
on
If you
if
get- if
not
you get
substantially
a
similar.
state, people be entitled to get license in Texas.
If they were a funeral director licensed somewhere else, yes, sir.
Actually, funeral directors,
Right.
but have never been to a accredited school.
Right, and as long as they're in good standing and
I don't see Jim Pitts throwing up a fit yet.
Okay,
Thanks.
it's just for the time that they are in Texas.
and
Then not
under,
renewed.
and under those orders, right?
First name to the military.
You should have the option also to not hire if you're not comfortable. Like, it's not like they could open up their own, I'm saying we could, as funeral home owners, we don't have to hire if we're not comfortable with the license type that they have. Where they,
You wouldn't know.
I was gonna say, that might get
You
into
wouldn't
the
know. They have the same color license.
oh,
But says substantially
Well-
equivalent, right?
they don't have.
No, not for federal law. Federal law doesn't have to be substantially equivalent, it just has to be a license. But that's where we're working on of practically what that's gonna look like, because it's an authorization. So we'll get into probably the practical. I would just say, maybe also talk to an attorney, because you don't wanna get into discrimination
Yes.
based on stuff. And so some of that is gonna be outside the commission's jurisdiction.
Yeah.
So I would just say, talk to someone before moving forward on that.
Are there other agencies that practice this same?
All agencies, it's requiring, so all agencies are undergoing this rule change right now.
So for example, the nursing board would be equivalent.
Right, and I'm like, cause I actually kind of looked at the pharmacy board and some of this draft to kind of, cause they're a little bit ahead of us in adopting Senate Bill 422. And so, no, this is affecting all agencies, and we're also the governor's kind of giving the directives of agencies to expedite this implementation. So it's not just us. Yes, sir.
Why couldn't the commission issue a different colored license to them? Because they're temporary,
Well, and
they're
that's
under
what,
the military.
well, that's what I'm saying, like, we may do that, I know we're doing that, like, for example, when we have criminal history applicants, who have passed commission approval, but they're issued a probationary license for the extent that they're on probation, they're given a, what do we do? They're given an orange one until they successfully complete their probation. So we'll have a process. We just have to have conversations on what that would look like.
And see it,
Have a camel license.
yeah. And so, there's some things that, are not waivable. To that point. Some things that are not waivable, to that point. Criminal background check. We're gonna check criminal background. We cannot waive the mortuary law exam. Okay, so you just can't walk across the border, and I don't want to pick out any particular military state installation, but you can't walk across the Oklahoma-Texas border, Chet, from Fort Sill with a funeral director license and say, I'm a spouse, you know, give me a Texas license. You gotta do a criminal background check.
And the rule does require us as the commission to independently verify that they are in fact in good standing, not just rely on
Yes.
what they provide. Sorry, I didn't mean to cut you.
No, you're good.
Second, okay, let's see. Then the last two aspects, 203.64, this is again kind of based on what we've been currently operating under for years about active military service members who are licensees are exempt from paying license fees for as long as they're serving in military service. Nothing changed there, it's just again making it all in one place. And then 203.65 is something we're also looking to apply to all licensees, but this is more of kind of like allowing us to temporarily give an electronic authorization until the military applicants can receive the physical license in the mail so that they can start practicing and not have to wait an additional time and out.
Yeah.
We
They drop that. We've had some, we're still working on some things, from a mechanical standpoint, so we may drop that. We've got great staff. We think at least I've been confirmed that we're getting more efficient. I'm not saying we are efficient, but we're getting more efficient in getting, of course, somebody will raise their hand and say, I haven't got my license yet. Okay, but we're getting more efficient in getting those out. So we may drop that. We're running into some technical issues that we still have to work with our IT folks on. So we could probably drop that.
Okay. I guess then my question is, do we want to give everyone time to now look through the language before going over and just see if they have questions, or how would you like to?
Let's see if, let's just see.
Oh, that's a good idea.
Yeah, we can definitely, but let's, do we have anybody with their hand up? Remotely, on the remote? Just want to make sure we're not forgetting those folks.
But you're just having to conform with federal law.
Federal and state law.
So more federal, and the governor's
Well,
telling you
yes, sir.
to match
The
it,
SB 422 and then federal, yes, sir.
move forward. IRS is.
It's a language issue, that's all.
Don't see anyone with their hand up.
Okay, we have one. Yes, Mr. Altieri. Yes, Jason?
Okay, are you able to hear me all right?
Yes, sir.
Okay, great. Thanks so much. So I don't know the order of which we're going to discuss things here. But in getting back to the proposed 203.59 and 0.60,
Okay,
and that appears to be when somebody doesn't actually have a license, but is coming in with military experience,
Correct.
training and things of that nature. So I'm wondering about how this is going to, in the end, show itself. How is it going to be? What is it going to look like? Now, I have the greatest respect for our veterans and military. I have a son who's active duty and actually combat soldier who just came back from a 9-month deployment. So I'm very, very aware and very supportive of this. But, you know, for example, you know, the MOS for mortuary affairs is one that, you know, in the overall experience, you know, in the military as a funeral director, you know, there's no merchandising experience, no pricing experience, no FTC. There's none of going over that. No preparing purchase agreements, presentation. There's no presentation of these items in the military. Things are very prescribed. I think the MOS for mortuary affairs is, I think, 7 weeks. The training, I know there's tremendous experience that goes along with that. But, you know, as the commission, you know, in the mission statement, you know, as clearly mentions that, you know, arranging for a funeral is a major consumer purchase. And, you know, and so I always am concerned sometimes that, you know, the military experience is going to be very specific, very prescribed, and it doesn't get into the actual retail aspect of, you know, working with families in that way. And so I think it's important that we have a very specific and robust system for evaluating. And I don't think it's so, you know, I don't think it's fair to the consumer to simply say, oh, I had experience in, you know, in mortuary affairs, and therefore, you know, I should be granted a license. You know, would this include things such as being granted a provisional license? You know, and so I'm just asking and wondering, is this going, you know, what is this going to look like as far as the evaluation aspect? And you know, do you ever reach out to those who have experience in, you know, curriculum with mortuary science, and, you know, can further help with evaluation of these areas? And that's it. That's all, the only question that I had or comment.
Yeah. And, oh, we have someone else.
I 100% disagree with that because I am a former mortuary affairs NCO, and he is correct in a sense. Every individual does not get the opportunity to meet with families, but a select few are selected to go to Dover Air Force Base, whereas you become the liaison for that particular entity that you're in, whether it's Army, Air Force, Navy, so on and so forth. So you do get to meet with the families because this is someone who paid the ultimate sacrifice. So they do have to select the casket. They have to select the funeral home. They do have up to $1 million of insurance that you have to make sure the family is abreast of all these things. Not specifically Federal Trade Commission rules, but in actuality, you are meeting with these families and you are the first line as far as funeral services go. So not only do you meet with the families, but you're also selected to participate in the bombing activities as well. So the mortuary affairs MOS in particular does not do that. They're not training you on the whole spectrum, but those individuals, it's only a select few, are selected to go to Dover Air Force Base mortuary, whereas you have the opportunity to do everything as far as funeral industry is involved. That's it.
Yes, sir.
Yeah, and
I don't necessarily agree with what he says. When a service member dies, there is this person that's called the survival assistance officer. You're familiar with the survival assistance officer. He is the one that walks through with the family on what they are doing, what they want, merchandise, etc. I don't think the mortuary affairs person does that. I don't see that happening because they are wherever, and the family is in the States, and the survival assistance officer is the one appointed that goes with them in helping select that casket and merchandise, not the mortuary affairs people. No.
It's actually called the Casualty Assistance Officer, but as a liaison, you do coordinate all this stuff. I had the opportunity to be at Dover, and this is what I did. But you do have the opportunity to reach out to the families because you're the liaison from the Dover Port Mortuary. So not only do you coordinate with the Casualty Assistance Officer, but everything also filters to you as well, because you are the one receiving the remains. You are the one coordinating as far as everything from the time that remains, that soldier, sailor, airman, or civilian comes to Dover Port Mortuary, all the way up until the time they get to the funeral home. You are coordinating with the Casualty Assistance Officer as far as
Okay,
everything.
so a funeral home is involved in this process.
Absolutely.
Okay, so there is that aspect where they will have that a funeral home involvement.
Yes, sir, because you have to
Okay.
coordinate the transportation from the airport, which
Right.
is more than likely Philadelphia, all the way up
Mhm.
until they reach their home of record. So you are very instrumentally involved in the whole planning process of that individual getting to their home of record with zero discrepancies.
Absolutely, absolutely. But the funeral home is involved in the process.
They actually, once the remains get to them, well, once they unload the remains off the plane, then
Yep.
that's when they fully take over. And they're gonna have
That's
a escort with them at all times. And
Right.
again, that's when we fully turn everything over to the Casualty Assistance Officer.
Yes.
Yeah.
Okay.
And I have the military
And-
contract here with Fort Bosses. I've had it since 14. There's like a 2063 form. The family has different options they pick with the casualty assistance officer. We do all the embalming, preparing, and we take them to the airport. And we work with casualty. I do work with them a lot. I mean, I do know that they don't really get a lot of how, handling the program, like that part of the funeral, but if they could do the provisional, I think that would be, because it is a lot of the same, but I think a provisional would be nice to have, just so they could see the other part with the public more.
And thank you so much for your work with your facility with our veterans. I think what we could look at doing, and we've looked at, kind of just out the side of our eye. Yes, Mr.
I
Hill.
just want to throw out an idea for y'all to consider as y'all are, because obviously, because of the federal law aspect and the state law and in particular veterans, you might consider wherever you end up with on how you license in this case, you might consider prescribing a more special, and it may require a law change, I'm not sure, but if you have the latitude, if not, maybe we request change in law, so you do, to on the back end, where you able to prescribe continuing education, specifically where you mandate courses, like we only mandate the core, the law and stuff. Well, maybe in these cases, you're mandating some continuing education in the future. So then you're fully bringing and orientating them in. Just idea.
And then where we're, and before I get to, just Harvey just reminded me something, before I get to my ultimate point. When you look at these state statutes, 55.007, especially, the commission, matter of fact, no licensing agency can waive any exam requirement. So at the end of the day, that includes the mortuary law exam, that includes the national board exam or whatever exam that's prescribed, or exams that's prescribed by the commission. So it's not, I get out. So for example, you know what I did? I was an infantry officer. None of this would apply to me. Matter of fact, I tried not to get involved with mortuary affairs for obvious reasons, right? Okay, all right. So none of this would apply to me. If I came to the commission seeking licensure, I would be told, here's your provisional license application. Okay, here's your mortuary law exam application. And James White, you need to get after. Okay, so those are some things to think about. Okay, also, as we've studied other agencies that have been in this space a little bit longer than we have in this manner, I believe Mr. Altieri brings up a good point, where we could convene a committee to look over the past conditions and standards of these individuals, okay, and how it matches up with, non-essential, essential tasks for provisional, how it matches up with things that go on in the school, okay? I think, you bring up a good point, okay? Obviously, if I'm transitioning to the civilian sector from the military, there's just some things that are different. It doesn't mean I can't know how to do them, but maybe that needs to be a consideration that, you do a provision, okay? So, I think it is, I think Mr. Arteria brings up some very good points that we could convene, stakeholders together to say, how does this look? Okay, I think TDLR has done that, where they have looked at every MOS in the Army, Navy, Air Force, Marine Corps, Space Force, Coast Guard, and you can go down and you can see, because I actually played with it, and I put in 11 Alpha infantry officer, and I qualified for nothing. Plumbing, electrician, for nothing. Based on my experience in the military, I think for our commission, it would be a very, 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 very small cadre of applicants that we would even consider for this. I think there's one company of mortuary affairs right now in the Army, Army, Air Force, Marines, they pretty much train together. It's easier on the embalming side because the Navy does require their embalmers to be licensed. So they're licensed in that state and they've went through an accredited license program. So it's going to be a little easier for embalmers. I think if you would call Fort Lee, Virginia, which I have and talked with them, they would say the mortuary affairs instruction as of now does not include any science. Yes, those men and women may assist, but it does not include any science. So I think, Mr. Arteria, your points are very, very valid. And I just say we convene that group of stakeholders to provide more context to the office staff on how we work with this. Yes, sir.
You're absolutely right. I agree 100% with Mr. Arteria. And again, I truly believe if it were a regular mortuary affairs soldier that was just regular mortuary affairs, didn't have the opportunity to go to Dover, was told to take the national board exam, they would not pass. But the fact that I had the experience of going to Dover and being able to do all these things, you're able to actually get into that national board exam, and it's not a foreign language to you. Those other individuals, it's a foreign language to them because that's all they were doing, preparing for wartime environment. On the civilian sector, it's totally different because you're hands-on with families. So again, I agree with him that in the event we're using substantially equivalent background or whatever you have, the national board should be a requirement because that's when you really see who has the competency to do it. You know, not only on the provisional side, but actually on the national board exam, because that's going to tell the tale, in my opinion.
Okay, so I think we just keep that point and just convene a group of stakeholders to see how this would how we would execute it. Yes, sir.
Just when we're talking about the national board, we need to be aware that in this state, we're in a parallel universe and we're working for having our own Texas state exams.
Yes, sir.
So language in the actual rulemaking process needs to not just mention the national board, but or a state equivalent exam or something, some language like that.
Or exam prescribed by commission.
For exam, yeah.
And we already have in there just any license examination requirements, so that way it catches any.
Yes.
Okay.
Since we don't have our copies, we'll have others. See, we don't have a copy of this.
Yes, yes. And so what we'll do is I'll put my email address in the comment section if
Oh,
they're,
they can.
yeah, and they can too. The folks that are on remote, right? If they would like to weigh in, send a question, they can do that. Obviously, they can raise hand. What we can also do is we can get this online as well. We'll get it on our website as well. And if you want a copy of this document, just send me your email address via what is this called, chat on here, and we can send it to you as well.
Or if I shoot you.
Yeah, okay. But they can just send me their email now. We can
Okay.
get those and we can send it to them.
And just a little input, I'm
Mhm.
sitting here listening to all this, and it sounds like New Mexico has it all figured out. Because they have FSPs, which are licensed funeral director and embalmers who have gone through the process. They have interns who have not. So those military personnel who may have never gone through a program could come to our state and receive an intern license.
But that's also, and that's where that substantially similar
That's a
and
different path.
something come in,
Yes.
yes, sir, like there, and that's where. Like if you go through, cause it's a very thorough process of what has to be checked in regards to. Like the kind of license they're applying for, cause again, we're incorporating our provisional programs in this. I had to use the term apprenticeship because statute uses the term provisional, saying we can't award a provisional license, but I think they're defining I know they're defining provisional different than what we're defining it. So that's why in the rules, you'll see apprenticeship is technically our provisional program. I just had to make sure a person who's not in our field knows we're not violating state law by credit, like also considering military experience training, blah, 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 for an apprenticeship license or AKA the provisional.
My son hires 2 spouses of military personnel that came from California to Las Vegas. And he says he gets a lot of that coming in when they get transferred in and out. So
Okay.
we're prevalent, you think?
And that's probably part of that, like one-time authorization. So,
Yes,
I guess.
right. And there's a time horizon there, right?
Right.
Okay, what's that time horizon again?
Like it's just like first, in order for them to do, they have to notify the commission. They have to have been practicing actively for 2 years immediately before the application. So if they've had their license for 10 years, but the last 5 they haven't been practicing, then they can't get their license recognized here through that. They have to go through another alternative. And it could just be the regular licensing way, depending on what else they meet. And the license has to be in good standing. They can't have any like complaints or any of that filed against them. And there's one more, but it's in that the new 203 points.
And you did say they have to put this in spouses, right? So they.
Well, it's veterans and spouses.
Okay.
I'm sorry, members and spouses, not
Okay.
veterans. And then we have to process it within 30 days. They have to also provide military identification and military orders to verify.
It's the way we're practically envisioning it in the office is having some expiration date when the orders run out. Now, obviously, sometimes you're gonna be somewhere 3 years, right, Chet? But you don't know exactly when that 3 years is going to end. So we can set a date 3 years later, okay? And we do have mechanisms in our licensure platform where we can, every 6 months, every year, we can reach out to that licensee and determine, are they still in the state? Have you got any certainty on when, you'll be transitioning out? So we'll be able to do that through the license platform. Yes, ma'am.
And just to caveat on that, 3 years would not go beyond any express deadline set in the military orders. So it's more of like if you come to the state and you immediately want to start practicing here, and let's say your orders are for 4 years, then we wouldn't go past 3. Now, if it was under the federal path, we have to do it for the whole period after the order duration.
Yeah. Now, temporary duty, you're familiar with, right? You're going to a certain training, and you do know that training is going to end in 6 months. okay, and your orders say that, okay? Because it's really based on the orders, more so the 3 years, okay? Because if those orders are just for 2 years that you're in Texas, then we're gonna set the expiration date for that license according to the orders. Yes, sir.
Would discharge type have anything to do with this?
It does state honorably in there. It does.
Because otherwise that kicks you into other situations, right? That'll come up in your criminal background possibly. Okay.
Because like you said earlier, we still have to do the criminal background check. They're not exempt from that part.
It does.
Yeah. Okay, so they got it.
Yes.
All right,
I don't know if there's any questions.
any questions?
We should.
Some instances. Yeah, yes, ma'am. Okay. That is a very, very meaty rule there. Instigated primarily with 2 pieces of legislation and then just doing some catch up. Okay, let's
Real quick,
yes,
just for
ma'am. Oh,
clarity,
yes.
can
Oh,
you
yes.
tell us one more time, which one was the federal law that we're, just so we can put the puzzle together?
It's in there, but it's 50 USC section 4025 small letter A.
I guess if you look it up, it's a lot longer than this one page.
It's actually not,
That's pretty condensed.
I don't know I don't have the full rules, so I'm not, I mean,
4025A.
when I printed it out, it was like 1 page front back.
Yeah, let's do this. Miss Haynes, go to our front page on the website. 'Cause that's where we're gonna probably transition to anyway. TFSC.texas.gov. Okay, scroll down, okay? And you see military licensing, military_licensing PDF there? Yes.
That's why I said if you're having to conform to what they're saying, pretty cut and dry.
Okay.
And
Yeah,
that's why that option B pretty much follows that.
But I like you have a different path.
and so right here on our front webpage where we've announced the stakeholder meeting for the day, there you see it right there. And it's 50 USC 4025A, portability of professional licenses of service members and their spouses. And there's a link to that.
Does that link open on your screen?
You want to click on it? Yes. Click on the federal legislation, down, right there.
I can see how short it is.
Those are usually the laws you want to watch, the ones that are small. Okay.
Glance over and go.
Oh, there's nothing
Sneaky in
there.
here.
Yes. Okay. Any other comments or concerns from our folks? Yes, Mr. Walker.
I'd like to see another draft of this sent out
Okay,
when it's all put together. So it's readable, we can follow it through, we know what the sections are, we know what it is. A little bit difficult right here.
So this is what I'm required to post with the Texas Register. How you see it is how it's gonna be posted.
right.
And are you on a timeline? Because the governor's
And in
evidently.
statute, hopefully we're supposed to have it by December 1st.
Okay.
Okay. I think what they're asking is like, if you have it where the current rule is and then
I mean,
they can trace the changes,
what I can.
like what you're taking out,
right.
what you're adding in.
What I can do is
Mhm.
just give you the draft language and take out all the preamble. I just wanted to make sure you understood, like, that is the final product kind of thing. But I can send just the rule draft language.
What we may want to also consider, we will consider because 2302, I think some of the 2302, you know, just like we would do when we would have a bill pass,
Okay.
and you got the original language, and then you go to the floor, it's a little bit different,
Yeah.
then you go to conference.
Just track the
Yeah,
date.
just right.
Think that's.
Well, I was
Why do you
more
think-
interested in the end result
Yeah.
versus the middle and the front.
We're not at the end yet, is what you're saying. I mean,
Your attorney's saying you pretty much
but let me ask you a question. So this is, when it gets to the Texas Register, then it's a proposed rule, right? So then you're subject to comment and a whole nother round of this written, and this is input even before the official comment period.
Right.
Right.
Because like, we're trying to get the ball rolling because of that 30-day required public comment time. Yes, sir. But I can certainly do a side by side to have it right, that may assist in the.
Okay.
If that sounds good.
Okay. All righty, so, in your packets, if you're here with us physically, we're ready to move to another, another rule. And let's go. You want a break? Okay, would you guys want a break?
So just real quick, is there like 8 things in the?
Okay. Okay, NFDA, okay, hey, thanks a lot, Chris. Okay,
Go down maybe. Is there anything- What? Okay, okay,
yeah, some of them was about to hear it.
okay, that's so bad, okay.
Okay, do we need to take a break? Anyone?
Break would be nice.
Okay, let's go ahead and take a break. I have 11:05. Let's just go ahead and make that 11:15. Okay, we're gonna take a break. On time, let's go ahead and look at some of the proposals or thoughts on continuing education. And in the proposal in the summer that we received is that there would be some number of hours, I think 4 was mentioned, okay, where the licensee would have to do in-person continuing education. All right, and go put that up on screen. Yes, okay. Okay, so okay. So this is what we're looking at, okay, as far as a proposal and changed language. So let's allow the the rule drafter to go through it.
Well, just really quick, because what was posted online, I wasn't sure who all had already provided feedback, so I left some of that in there. I just added to, because we unfortunately didn't have time to really go through it all. So, the first, so under 203.8 F2, it talks about what the law updates have to include, and it's chapter 651 of the occupations code, and then it had chapters 193 and 716, I think, already for the health and safety code. But in just the 5 months that I've been here, we've received several calls from licensees who have questions that fall under 696, 697, and 711. And so I wasn't sure, I mean, really 691 through 716 would be great. This is kind of where I'm leaving it up for feedback of, because some of that includes like the disposition of fetal and embryonic remains, disposition of unclaimed cremated remains, the burial requirements and casket identification. So some of that I just didn't know from you all who, I mean, this is what you practice every day, if you would like to see the mandatory law continuing education updated to include more than just the 651 and then Health and Safety Code 193 and 716. I'm not married to it anyways. It's just thoughts, again, based on calls that we get in the office that we tend to hear about. Yes, sir.
So I think that the idea behind this is to make sure that at least once every 2 years, all of our licensees are brought up to date to what the current rules and regulations are and what specifically what the changes have been over the last 2 years. And I think that's the kind of language that needs to be in here, not quite as much
Like specific.
substantive chapters and verses, because we might already know them by heart, and not only that, but they might not have changed in the last 2 years.
So maybe something that says, instead of this, like must cover most current versions of law that applies to the funeral directors and embalmers, including any updates passed by the state or federal legislature or something like that.
Yeah. It really, because it's law updates. So we're looking for changes.
That's a good, I like that. That's good.
Sarah, I'm a little confused because the packet is worded differently than what's up on the
Yeah,
screen.
this is what some of the proposals were.
And then you've taken this and made it, so the packet is the language that we're going to post.
This is more, because there were some things that we needed to hammer out in this meeting. So that was one. The next one was, because I noticed when I was working on a draft proposal, was that in, let's see, 203.8. Is it G? No.
16 hours.
Right, where is that? I'm losing it.
It's on it's on the first page of this section.
Here.
Oh, she's in the deal. I mean, she's in the actual current rule. Yeah, she's looking at the current rule.
G, so it's 203.8. Letter G says 16 hours of continuing education may be taken through internet online presentation. But in subparagraph H, it says the credit hours outlined in this section are which is for attending commission meetings, are eligible to be counted toward the 4 hours of required in-person continuing education. So we've got a discrepancy of one part saying that we do have a required in-person continuing education requirement, but then we have G saying there is no. So I think that's where we need to hammer that out of what is it that y'all would.
Or just harmonize it. Yes.
Yes, if you can, please. Thank you.
So I think the 4 hours, as we have talked previously, the 4 hours of in-person or webinars where there is question and answer, sort of live webinars would count as well. Came about 4 years ago when we were doing this rule change, that we didn't want people to just go through the 20 minutes it takes them to do the 16 hours by some sort of computer course and going to the exams, filling out the exams, passing every one of them and being done. We wanted some more substantive education requirement. So we said, okay, how about 4 hours in person? Or using the web, but it can't be just presentation mode. It has to be a back and forth with questions and answers. It has to be a live presentation. And so, but during COVID, right at the start of COVID, when nobody could do anything, the commission struck that rule or put it in abeyance until after COVID. And so now we're back to it again. So that's sort of the history.
And so then my question is maybe rephrasing to where where we say maybe just striking,
First part of G.
yeah, or where we can just say 4 of the 16 hours must be in person, or and then put something that says a live recorded where a live,
Recorded,
right, or internet
interactive.
teaching course where there's an opportunity for Q&A is available, can count as.
Right,
The
actually, the
in-person
last sentence here is very good, actually.
Sir,
Like
Oh,
this Zoom right here, we don't even know if they're sitting there behind their computer.
you can see a name, but you don't know if that's actually the name in the seat, yeah.
so recently just took an ethics, continuing ed for my legal license, and so I was doing it based on that course, because it met live in person, so I was just trying to do it where.
Right.
So that's the proposed language I have in G, which is underlined for those, on Zoom. That's kind of what we were thinking of how to, because we understand that, like, especially if you're in rural areas and you can't go to a big city, or maybe they don't offer it at a good time, people have small businesses, like, we know that you can't always. Oh,
All
nice.
the vendors
Uh-huh.
will develop a program that goes out to building Texas. Give 2 hours again.
Oh.
So that's never been a problem.
But the fact is, it can't just be recorded.
Why?
Why?
Out of curiosity, why?
Because then you don't have the interactive part of it. So then it just becomes like a taped program.
But is the comprehension from a taped program any different from the
Yes.
interactive?
Yes.
That is that is an opinion, and I'm sorry, I don't know how to raise my hand to ask how to speak. But we do not all agree. I'm just letting you know, there are many of us that do not agree with the in-person, and it has appeared in the past that most of the individuals, now not all, but most of them that want the in-person are ones that actually benefit off of it financially. So I'm sorry, Sid, I disagree with you. I've always disagreed with you on this.
It's okay. It sounds like Jay, but I don't have a
Jay.
face with a name.
You know that's Jay.
It's
Yeah.
today in a market where community education is available within 30 minutes is anywhere. So.
Right. I mean, the point is, what we're trying to get away from is having people take coursework, including some that the association has a vendor who's approved, to take only that casework where they go to the exam, they take the exam, they pass, they get the certificate. They go to the next one, they go to the exam, they pass the exam, they get the certificate, and they do it in 20 minutes, or not always do they do it.
I understand your opinion. You've shared that, but don't keep saying we. That's an opinion from you.
No, that's how the 4 hours got into the rule, is we were at a stakeholders meeting just like that, including you, Jay, and it got passed.
I don't
What we
believe
don't want, as we have heard in other stakeholder meetings, is funeral directors having their assistants take their exams for them. That's neither ethical or correct, but they even do it for the ethics exam.
And another good benefit of having in-person CEUs, even on the chapter level, what we used to call regionals, is we get together in a group like this. And after that continuing education, we go off and we talk about other things that involve our profession. So we're getting more information just by being one-on-one with people. So there is a big benefit to having a program like that.
So one of my questions is just kind of here, because I think everyone has a concern of just, making sure good actors or everyone's complying with the law. So is there a compromise to allow to make sure continuing education is met without making it necessarily easy for people to cheat? Like, kind of going back to your question about how could someone not or how they may have a different comprehensive view. Like, one of the things people can do is just hit the button and you're in another room doing your chores or whatnot. So I think the thing is how to make sure someone's actually in good faith doing that. Now, granted, no one's perfect, but is there kind of like a happy medium of where we can find that? At least, I don't know. I know I did look at the medical board and then the state bar to see what their requirements are. The medical board defaults to in-person, but allows I believe in person to meet by something kind of like what, Sid was mentioning about where it's a live recording or where there's like an opportunity for, an active Q&A while the person is, listening, like the ethics class I did. It was not a live recording, but there was a live person available by phone should I have any questions while listening to the presentation. I could still listen to the recording at my convenience, like I actually did it in the office the other day, and which was better for my schedule, because then I could do it when I had like a break and something else, while still also meeting my educational requirements. So just some thoughts.
I'm gonna use myself as an example. I believe in continuing education, but also as a certified OFART, I've been through everything, okay? I think ethics is good, but ethics, how do you answer an ethics question without knowing the answer? Okay? There have been, I will admit to exactly what Sid's saying, is when I've come into a time crunch for whatever reason. Oh my God, I need 3 more hours and my license is due this month. I have the old exams that I've taken because I print them out when I do them, so I can go by the book. And I have gone through and pulled up the same CEU that I did maybe 2 or 4 years ago and go exactly to the test, and the answers are the same. It's the same thing that I didn't do that I found appalling going to mortuary school 40-some years ago, to where the big thing was to find somebody to sell a comp in and memorize the order of the questions on the boards, both from the school, from the state, and from national. They were all the same questions. They were all grouped in the same groups of 5. The 5s are rearranged, but all you had to do is recognize that question. Oh, this is B, E, D, C. Common practice. Ethical? No. Done? Yes. So I don't think it's so much personally being a victim of myself and trying to be ethical. It's not so much of how the is done, whether in person or recorded or something. I think it's a matter of the actual program itself having some type of fail-safe, and I'm not smart enough how to do it. It's like if it's a written presentation, it's changed every 2 years. So that if you go back and take the program, it's not exactly the same. Okay?
And it needs to be updated. Right now.
Well, I'm not talking about the updating the information, but and then if it is a live presentation, something to where, or as it's a presentation on paper, is there something there that you click every so often, if it's on site or online, to show that you're at least looking at each of the 30 pages of the information. You may not be reading them, but just to put some effort in there, and maybe some of that will blind up. Because what we need to take away is the cheating factor. That's what all of you are talking about, is the cheating factor. It's not so much the convenience, the inconvenience, the city, the country, how many hours. It's the matter of how can we regulate. Surely there's some way it would be put on the burden of those making the presentations and how the commission approves what is to happen, so that at least you're putting in more effort than going exactly straight to a test or putting on a screen, going back, doing it at your house in your underwear at 3 a.m, go do the laundry and come back out in the last 5 minutes and get your CEU number. That to me is the credibility part that we need to look at, is forcing someone to actually do more than just go the easy route.
So does that fall on us? This was what we were just kind of having a little sidebar here. Does that fall on us to only approve courses for 1 year? So they're good for that year. They have to get updated to get reapproved. So it's not the exact same material from year to year.
Year may be too much work.
Too much work.
But I think every so often or something, or at least maybe,
every 2 years with legislature.
at least maybe
2
the
years, yeah, that
program
makes sense.
not change the presentation, but the questions.
Well,
Because that's-
also, right now at Commonwealth, I'm enrolled in online classes. There are no fail safes online like that unless you're at a proctored exam.
Yeah.
For all the quizzes and all the assignments, it's just left up to just your own ethics. Now, it properly displays you shouldn't be looking at your book, but there's
I'm in the comfort of my kitchen.
Yeah.
So, and if the standard for mortuary school is set at that bar, then why shouldn't continuing education be an even higher bar? And just, trust that the people will do the work. And I think it would be a big task to try to manage the cheating side of it.
I know for legal, and some of the online courses, they've done, this last one, they use the same code in 2 different spots that you would have to type in to show that you're an attending. But I've done it in others where it's 2 different codes and you don't know where in the presentation it was gonna be. So you had to kind of pay attention, because one might be coming in the beginning, the other one like in the latter half of the presentation. And that to me kind of helps because it's a random code. You have no
I
idea.
think what we're gonna say, have to hit the button to show you.
I mean,
You want it in your back pocket, something, to verify it to you.
Just taught continuing education in the last month.
And you did
In
very well.
person. People come in, we know who they are, they have to sign in, they don't get the requirement until, they don't get that piece of paper until we know they've attended that class. And it works, in person works. The online stuff, I'm not so sure it works. I don't have any problem with question and answers like she's indicated here. The question and answering thing, because I can tell you that people are not going to do that to get a provider number. And you don't want to forget that. You've got to have a provider number in order to give continuing education, and you've got to pay for it from the commission. Likewise.
But that doesn't mean your coursework is up to date. As we have seen, there was a vitals course that was still referring to the death record system as TER versus TexEver. And when you have that, they're at least 5 years out of date.
And I'm glad you brought that up, because that's why I'm sitting here, that I have requested from the commission that vital statistics, which falls under chapter 193, be repealed.
Yeah.
And you all have agreed with us.
We're not picking sides. We just, whatever was said in the stakeholder meeting, we've provided that.
Right.
As a benchmark for.
But you have given other options like 696 and 697 that are in the health and safety code.
well, that was part of that conversation of it.
Right.
That's something.
Right.
But
So-
that was
so-
for law updates,
Yeah.
which I think is different than what we're talking about now.
Okay.
The law updates, we talked about a little bit ago, that it's going to be law updates. It's not going to be specific chapters and verses.
Right.
Because maybe nothing changed in the last year or two. But there were other things that changed, and that's what we need to know about.
Okay.
In this, we're talking about, 4 hours of live continuing ed, and also the provision now that also is in here where you get ethics. You get ethics credit if you come to a Texas Funeral Service Commission meeting, which I think is an outstanding idea. And it's a great way to get in-person credits and to get your ethics credit by coming to a commission meeting once every 2 years.
And I don't disagree with that. So is the commission still saying 16 hours? Or based upon chapter 193 that the funeral association doesn't necessarily think we need any longer? Are you reducing from 16 hours to 14 hours?
Well, what we're saying is big C, small c commission, okay? What we're saying is our engagement with the regulated community and other stakeholders throughout the summer, this came up. So we're putting it down for stakeholder input. And then, we can take this to the commission. So the commission has not picked a horse. So, these documents are products from what we heard from y'all and what we have statutory rulemaking discretion. Okay, so and I don't want to talk for the commission. I can't talk and for the
Sure.
commissioners yet.
Sure. Yeah, back to,
But we're just really listening at this engagement here.
back to what Sid said.
Okay.
I agree with you and I don't agree with you. Yes, we need the law updates, but that doesn't take 50 minutes to complete. It doesn't. We have to make sure we get 50 minutes by the clock for getting credit
For 1 hour.
for the continuing education. Now, having said that, I gave the law update recently, and it took me about 25 or 30 minutes. Good exchange. But the occupations code is big, and you'll be surprised how it's been there for a long period of time, and you still get answers and conversation in regards to the entire code. So I think all of the occupations code can be useful. Having said that, cremation is on the rise. Chapter 716 is the one that talks about cremation. The commission has just now put that there, that maybe that ought to be something that needs to be taught. And I agree with that.
Okay, we have one of our remote participants. I think it's Jay. Jay, are you there?
Yes.
Oh.
Can you hear me okay?
Okay, that's Jason. Okay.
Yeah.
Jason,
Yeah, you're-
okay.
But I'm here
Yeah,
too.
Yeah.
Okay.
If you're, can hear me,
All right.
oh, Jay. Yeah. So Jay, Jay Carnes, did you have your hand up also?
No, I did not. Thank you.
Oh, okay. All right. Good deal. Hey, so just, from somebody who has taught hundreds of continuing ed courses, and, thousands of 4-credit courses and so forth, I think it's important to have, some additional input, and there's been really good discussion, continuing ed, you get out of it what you put into it. And the regulation of these courses is, and people's behavior and so forth is difficult. And, I'd say from having taught a lot of the in-person continuing ed courses, there is no guarantee of the, number one, the quality of the program. You'll have, from the presenter aspect, you have the material aspect, and you have the attendee. Just because somebody's sitting in a continuing education course live, it doesn't mean that they're getting everything out of it. People are on their phones, they have earbuds in, they could be doing anything except paying attention to what's going on. So there's absolutely no guarantee that having a course live and in person is going to, be a better quality experience. It also seems that it's up to the Funeral Service Commission. You all approve the courses, and it's a lot of work, but there's a great deal of control from the Funeral Service Commission itself to go into the approval process. And I've done a lot of, I've developed a lot of courses, distance education curriculum and so forth. And the one individual who spoke of that, hey, there's a lot of opportunities in a kind of unregulated environment online to, if you happen to take a peek at your notes while you're going through something, again, it happens, and it is, or going back to your old exams and so forth, that's a personal choice. And if that's the direction that you're going, once again, you're, getting out of it what you put into it, and which is not much if you're doing that. Perhaps it's a refresher. But I just think that in person is no guarantee that in regulating this aspect, that we're going to regulate that the person in attendance is having a particular experience is very, very difficult to do. So anyway, that's just from my experience, just something I thought I would include.
Okay. Hey, thanks a lot, Jason.
So I'm gonna summarize as the old guy in the room who doesn't have to do continuing education.
Okay.
So 47 years ago, continuing education's had 75 people in attendance on a regular basis. So did we get a lot out of that? Quite a bit. Did we get more out of the discussion we had afterwards? Absolutely. So here's the visual part that I want to kind of give you. I had to change my radio the other day because the clock's off. Now I could have gone to the manual and read everything, or I can go to YouTube and watch it. Which did I do?
YouTube.
I went to YouTube. It's so much easier. I got to visually watch how to do it. I'm watching the person push the buttons. I probably couldn't have done it if I had to read the manual. Online, in person. So, and there's so much going on. Cremation is the big thing right now. How many of us are having to move our business from traditional funeral to cremation? Everybody is. So what techniques do we have to now come up with? And who is that person out there that's really good at it? Maybe is the person that's sitting in that classroom teaching all of us the new techniques of cremation selling to get that client family off that direct cremation into a memorial service. And how beneficial is it to not only the funeral director, but to the company that they're working for.
And also the green funerals is also a new and upcoming topic that funeral homes are looking at, are actually, the consumers are actually coming to us. Even very traditional consumers come to me and are looking for, how can we green this up? How can we make it more environmentally friendly? And you know, you get a lot of you get a lot of education ideas when you start talking to people, and that usually comes from in person or online webinars where there is group discussion or the availability of group discussion versus just putting your earbuds in and listening to a podcast as an educational tool.
Okay, we have a point. I think, Jay, you do have your hand up now. Jason Carnes, that is.
No, it's Jay.
Jay Carnes.
Jason Altieri, but that's okay.
Yeah.
But actually, it's going to be Tim Baker wants to speak.
Oh, okay. Go ahead, Tim.
Thank you, Mr. White. I just wanted to add a couple of 2 cents in off of Mr. Altieri's comments. I'm in total agreement with Mr. Altieri that comprehension is different for each individual, and just being present in a classroom, you can go back to any formal education you have been through. You have those that glean and do well in the in-person setting, and those that are, again, on their phone, daydreaming, whatever, it doesn't matter. Others do great online. Others do not. And again, I agree, Mr. Altieri, it comes down to the individual and what they want to get out of it. But if we're going to step back and look at what we're talking about here from a stakeholder standpoint in regard to our continuing education, whether it should be any requirement for in-person, the commissions has designated, okay, there's 16 hours of continuing education as a regulatory body. But do we really want to have the commission get into the weeds of being a policing body now, saying how those 16 hours or part of those 16 hours have to be obtained? Shouldn't we leave that up to the individual? As the regulatory body says, okay, there's 16 continuing hours, shouldn't we leave that up to the individual, the licensed individual, on how to obtain those 16 hours and not put the commission in the seat of becoming a policing body now? Thank you all.
We are in a policing body because you have requirements every 2 years to put in your CEUs to renew your license. There is a 10% audit factor in each of those months for license renewals to check and see how those are being handled. And so we're already in a policing, and part of the commission, that's how we protect Texas consumers, is by being a policing organization as a commission. So.
No, that's a regulatory body, Sid. Those are regulatory requirements, not policing requirements. I disagree with that.
But you approve all their courses,
By rule, we
You have
must
to.
approve all courses.
so you're already doing it.
Right. However, I don't know if there's and I guess that's why part of the reason we're here. I don't know if I have if we've given Maria and her team, well, really Maria and I, an express requirement that, we have to look for certain courses, maybe ethics, or, we have to look for a certain number of hours as being in person. We don't know if we have that express authority to enforce that on our licensees at this time.
It just says that the 4 hours should be in person. It
No,
doesn't say
right.
what 4 hours.
Right now, there's no, and it's still
On the
80 hours
proposal.
online.
No, it's just
No,
the extra
no,
4
in-
hours.
It does say it in H now.
Yeah,
In
and
H.
in H, that's where I was saying, that's why we've got this discrepancy. We need to hammer out to see which direction we're gonna go.
I would include one. This is Jason. I'll
Yeah,
peer.
Jason,
It's not an category.
let me hear Jason.
I apologize if you've addressed this aspect of it, because I was kicked off of here for a second with the internet, but my days of being in Amarillo and in the Panhandle and in the rural areas, it brings about it's much different in Houston. The ability to attend courses and so forth might possibly be a little bit easier logistically, but if you're a small, you're in Dalhart, Texas, furthest northwest county, and you are the only funeral director, embalmer, and you're a couple hours away from biggest city, which is Amarillo, and it presents a problem. So I think one of the things that for being in person, and I think one of the issues to consider is the rural aspect, and considering all of the funeral homes that are out there. Not all are going to have the access and the ability to attend a program. And I know the argument is, well, they should be able to get away for 4 hours. Hey, if you're the only person in that small community and you get that first call, and I can remember teaching continuing ed courses that were in person in Amarillo, and I'd have folks sign up ahead of time, and my list was always completely changed from folks who were called out at the last minute to folks who were able to get away at that time. And that's just the reality of it. Anyway, I just wanted to throw that in.
But in this provision, we seem to be focusing on 4 hours of live discussion, but there is in that same provision an alternative for anyone to obtain those same hours by using live webinars where there is a discussion component to them. So the whole fact about being in a rural city in deep West Texas, it doesn't really apply because we're giving an alternative way. It's 4 hours of in-person or live webinar with a chat component.
Right, and I
Every
would
2
say,
years.
I would say yes, and I understand that we're talking synchronous versus asynchronous, and it still applies. If you are that one person at that one funeral home, whether you have that live course coming up, and they're not going to be necessarily offered, every day, and you have that call come in that you need to take care of, you're done. That's it. Because there still is a delivery aspect, and there still is this area of it being a synchronous course versus an asynchronous course. So it does still apply. But anyway.
College anymore. You know, one question from resource that I think staff would have in particular to Attorney Hartsfield is, I'm just thinking about, I think I maybe had about 15 approved providers, maybe a few more than that, for this year, 2023. The ones for 2024, they're coming in as we speak, okay? Would any of this decrease the number of providers? Well, would it increase the number of providers that would be able to be in this space of continuing education? And I need, some of y'all are involved in continuing education, so you would probably know.
There is lots of continuing education available today for anybody who wants it. Between NFDA, TFDA in the state of Texas, ICCFA, another national organization, other vendors around the country who are giving regular webinars, whether it's on their own particular product or other wider ranging topics like green burials. There is a plethora available out there, and anybody should be able to get as many credits as they can do or want to do each year by doing this. I am certified as a funeral service practitioner. I have to get 20 hours a year, and I manage to do it every year easily. That's way more than what this state requires a funeral director to get. But there are lots and lots of webinars out there. I get lots of emails about them every week, and I can pick and choose. If I can't make one because I'm dealing with a family, okay, that's the way that is. I'll go to the next one. There's another day and another webinar out there. I mean, there's literally hundreds of them out there.
Short answer.
Yes, sir.
Prior to being able to do it online, pretty much every vendor had a course they provided. Okay. And they go to locations.
Okay, on the in-person.
In person, yes.
So they were doing that already. This would just be
Like
going back
vendors,
to.
meaning like our lawn fluids. stuff
Right.
like that.
Okay.
And if you come to a Texas Funeral Service Commission, under the new proposed rules, you'll get 2 hours of ethics credit. What a great idea.
That was given to us this summer by the folks. Okay.
So the way it currently writes is you have the 2 hours ethics, you have to do 2 law, 2 vital, then you have to get to the rest of the 16 hours. Some other way, right?
Say that again.
No, so currently 6, so 2 ethics hours, 2 law update hours, and 2 vital statistics hours. But currently under proposed, we're removing the vital, so you would, if we kept the 16, or that, you still have to find 12 hours of education that you would want to.
Right. And we have the option that if somebody wants to go to the convention and there's a course that is eligible, because when you go to the courses at the convention, it'll say this is eligible for credits.
You know, I mean, because I think everything as it currently is, would probably still.
Otherwise, you can do them all.
I'm gonna throw this out there. Why do you, just definitely understand the ethics of coming to the commission meetings, because you get to see kind of what got people in trouble. You also get to see rules that are updated and the discussion of the new laws like we had at our last commission meeting. Why not provide the opportunity for at least one of the 2 hours to be coming to a commission meeting for law update? I'm just throwing that out
No
there.
guarantee of what we'll be discussing.
Correct, but that's why it's just one of the 2.
And I guess if we did that, we could provide maybe some verification of which meeting it was, because we could go back to the agenda and see if any kind of, I don't know if that might be too onerous on us.
But pretty much every meeting, we have something rules related or an interpretation of the law or
A lot of that.
yeah. I just throw that out there that it just made sense to me that at least one of those two, especially since you're saying you don't need more than 1 hour to update you on the law every biennium.
Well, the paradigm has always been to have a 2-hour ethics class because you need 2 hours mandatory. 2 hours vital statistics class because you needed 2 hours vital statistics. 2 hours of law updates because you needed the 2 hours. So they were always packaged in 2-hour chunks. Okay, wherever we went. I mean, whether you did it at the Texas Funeral Service Commission, Texas Funeral Directors Association convention, or you went to Vital Statistics to their convention, they were in 2-hour blocks so that you could, because this educational requirement required 2 hours in each of those 3.
I wonder if cause like the liability and government law conference we went, Mr. White and I attended earlier last week.
I got no
Last week.
credit. 'Cause I'm not-
Well, so in the agenda, they had a code that if I could use to get credit for my continuing education courses. So what if we did that for each agenda, depending on what's talked about, we would assign a number of whether like if we think the topics would qualify for ethics and law, then we could say, here's the code, and we would credit it for that because it's leaving it in our discretion, helping us control whether.
Or then are we taking a position on education outside of what we're supposed to be doing?
Ah,
Because the point of when it came into getting a credit for going to the commission meeting was
Mm-hmm.
because people brought up the social aspect of
Yes.
socializing, talking, shaking hands, getting to know people. And they wanted them to just kind of observe, but there's no guarantee that we're gonna check those boxes at those meetings.
Right.
I don't want us to put ourselves in that
Well,
position.
there's no statutory requirement for continuing education. This is all our discretion. So
It says and statute says
If we
do it, if we have to have at least one course in ethics.
Yeah, that's all.
Right.
We have to register ourselves then separately.
Yeah, it says, if the commission requires continuing education, commission shall require completion of a minimum number of hours of ethics training as a required part of that education. It doesn't even say
1, 2, 6.
yeah, 10, whatever, 651, 266 occupation.
I like the idea of also receiving credit for law as well as ethics at a commission meeting. For example, the Bill Valley was at my course that I taught 2 weeks ago, and he had to leave, but he was there for 1 hour. I could sign off and give him 1 hour. Well, next week, the commission is having a meeting. He could show up at a commission meeting and get the other hour. I like the idea of adding the law to the board meeting.
That gives incentive for someone to maybe if you're doing 2 for 1 hour twice for both law and ethics, that gives an incentive for us to come.
Each
to full
class
meetings.
has to be 50 minutes in length. And you all go past 50 minutes. So he got 50 minutes the first hour, and now he needs another 50. Well, I'm gonna go to Austin and go to the commission. He can pick up his other time because he signs in, and you have that documented. And that's what he'll put in when he submits the paperwork.
One question I've thought about is listening is, just to begin with, do we think we even have we have to do the ethics, all right? But do we, and this may just need to be a broader discussion going forward. Do we think we have even we have a pertinent, relevant suite of courses for 2023? I mean, I've listened to your discussion over the summer about vital statistics.
Yeah.
We're talking about different experiences.
Right.
Okay, and I think maybe a broader question, maybe, I'm just throwing this out, is, and again, this may mean we set this aside and we have more discussion. We have to do the ethics if the commission wants to have a continuing education requirement. But beyond that, do we even have the right set or mix of courses? I mean, I've heard a lot about the broadening of cremation in the marketplace. There's probably some other things out there. And just, you know, this.
Well, the only one required by law is ethics. The other ones, the commission approved.
Okay, we state what they should be, and then we approve the courses. And so unfortunately, I'm not a licensee. I'm not sitting down in front of our fellow Texans every day and knowing really what's really relevant today.
So that's where you rely on, you
Okay.
as the commission.
Okay.
And staff rely on, like, the conventions. Because the
Okay.
conventions are gonna have a mix of topics.
Okay.
That they're gonna have. And they're gonna submit all those people and their bios and their profiles and all the stuff that you
And we-
require to sign off on the, on, and give each course a number.
Mhm.
And then that package is what people who go to all the courses can get that year out of the convention. But it'll always be a wide range of
Okay.
coursework,
And we're looking at.
including ethics, vitals,
Okay,
and
right.
law.
So we're looking at those three that we have like in quote unquote Holy Writ. I mean, should those really be the three in Holy Writ? I mean, I don't know.
Right.
And you know, I think that's one thing we may want to look at. Yes, ma'am. Yes, Jay, I'm sorry. Jay Carnes, that is.
Yeah, I say you haven't got it right yet, but that's all right. I want to know, does the commission determine how many hours a education facility requires the student to come in? And if not, why would you require this? We're going the opposite direction. AI is out there. I mean, schools are going more and more online. If you want to do anything, put your focus into changing, you know, the information annually. And it's kind of what we're talking about here, but change that annually. Because heck, I go to these classes and I hear the same thing in person as I do online. But why would you want to make it harder? Heck, we're trying to do everything we can to make it easier for funeral directors. Heck, we're trying to get easier for the license, you know? We went to online to try to make it more accompanying for people to get through school. I think about these corporations and how much money it's going to cost them for their funeral directors to have to be out of work. You're just making it harder and harder on us as business owners if you're going to require us to send our people out when they can do the same thing online. It's just going opposite of what everything is going right now. So that I'll try to not raise my hand again.
Hey, please do.
No, keep it coming.
Keep it coming.
To Mr. Carnes's point, you can pretty much do all your cremation arrangements online. You don't even have to talk to anybody nowadays. Everything can be done. There's various cremation websites where you can just go online, you can make arrangements. And I think we're getting away, to Mr. Carnes's point, you know, it's making it harder, I think, for people. The in-person may work, and I think it's a great option, but also having the online, simple, do it on your time. My schoolwork, again, I'll just go back to Commonwealth. I can do my schoolwork at 2 o'clock in the morning if I want. I submit my paperwork, I submit my assignments, and that's good enough for my education. So why not the continuing part as well?
What's magical about 16 hours?
Well,
There isn't.
Who made the 16? It's just like
It
number.
got grabbed out of the air years ago.
Okay.
Yeah,
And
I
this
mean,
is what I'm saying. I mean,
As attorneys, what are you guys required to have a year?
it's 16 hours, 15 or 16.
My wife is counselor, she has to have 32.
yeah, I was
Yeah,
school
not that
teachers,
much.
just how many they
It's
wanted to
either
put on.
15 or 16, and public officials have to take 4 hours. You know, there's,
We did.
well,
Oh, yeah, we did.
for boards.
Yeah,
and-
yeah.
It's 3 hours for ethics.
Oh, yeah,
That's like
okay, those public. Okay.
I mean, to be a
So,
certified
let me ask
funeral
one more
service
question.
practitioner, we need 20.
I heard someone weighing in.
Yeah, this is Jason Alfieri again.
Yes, sir.
So a couple of things, you know, Jay Carnes made a really good point. You know, what roadblocks are being put in there? You know, I hear, hey, just to attend a convention. Well, what if I'm not a member of TFDA? Who attends conventions? My experience is there's a lot of business owners, managers, and so forth that attend the conventions. While folks are back at the funeral home, funeral directors, kind of the rank and file are there taking care of things. What's my cost in going ahead and attending a convention? It's just not that easy to say, well, here it is, just we have a convention, show up. That's a lot of times easier said than done. There's a big cost to that, as Jay alluded to. And then, I'm curious about the attending the meeting, which is great to get credit for attending a meeting, but that's in person. Is that correct? And there's no opportunity to attend a meeting like this via Zoom. So if I use my Dalhart example, I'm going to drive 1,120 miles round trip to attend a meeting. And so, it would be great to have an opportunity to attend some of the commission meetings at a distance, like we're doing right now.
So you can
Maybe
put it
all
in
the
as a,
continuing education courses should have a Zoom option, and then everybody is, they want to watch that, do it that way. If they want to do it online, do it that way. I attend, I don't usually have a problem. I come to things, so I don't usually have to worry about my continuing education, but I do understand, like, and I like seeing the in-person classes versus the online, just because I do know, and I know that my different competitors in town, they don't know the law, and it happens all the time. The customer comes into my place, they're like, they said I can't bury mom on my land, and I'm like, yeah, you can. You have this, because they don't know the laws, because they don't go to anything. But I think that if we had a Zoom, option like today, this was nice for everybody to be able to be here. I think they should just Zoom the classes, even at convention, they could do a Zoom.
so you could change the language in paragraph 3 that says 4 credits per renewal period for attendance at commission meetings. It could be attendance at or viewing by Zoom or whatever.
Like a live
feed.
Live feed, and then you don't have to travel from Dalhart or Del Rio or wherever, but you make the commitment to view the commission meetings via Zoom.
And it may be that if we did something like that, require where maybe either we have to see them or they provide some kind of verification throughout the meeting that they're actually on Zoom.
But to just throw out the bathwater with the fact that they're gonna have to travel. I mean, this is a really good idea. You want people to be more involved in Texas with the Texas Funeral Service Commission. So let's give them some incentive, which would be CEU credits, live or by Memorex.
Okay.
Because
I can tell
what's
you
happening is
one
we're
way to-
losing attendance on things because now people can do everything online. So we did lose a lot of attendance with all the different things that we do now. And so we just have to find other ways that it benefits other than just that, but because people aren't gonna come for everything in person anymore. But I think the live feed option would be nice.
Yeah, and one of the ways to verify, I know from teaching Zoom classes, especially during the pandemic, the requirement was, it's very simple that I have to see you. So, being able to turn that camera on and see that you're there and that you are actively at least engaged and listening to what's going on, or that you're present, is a quick way of being able to do that.
Or having to type in a code every 20 minutes or 30 minutes that's randomly generated in the chat.
Or you could just call roll call.
Okay.
Or just take people at their word.
Yeah.
Because I mean, look, we've sat in those classes before where you just, I hate to say it, I think somebody had mentioned earlier, you get what you put in.
Yeah.
It's just like creating the roadblocks that create more of an inconvenience in my mind, rather than, the quality of the information that's being shared.
Just for what it's worth. Well, we know this. Whoever is in this meeting, either physically or remotely, they probably know 203.8. Okay. All right. So let me just ask the stakeholders, what, do you just have I don't know if we have much consensus, what do you want us to send to the commissioners?
There's 50% don't want it, 50% do.
Okay, but there is some consensus on counting the meeting.
I think that is a given.
Okay,
Good, and I think that maybe we talk about the live feeding, like we could have had the live feed when we had, you do your classes, we could have live fed the class for you just did continued education for our chapter. We could have done live feed for that. I mean, why is that not, could that count?
That's where it kind of goes with that. One of the proposals in there is that the in-person could count if you had a live feed where there's options for like the chat or someone being live to answer any Q&A that comes up during the presentation.
What is the consensus on total number of hours to be required? Because I kind of brought that up and people were like, well, I don't know where it came from. We just started it and then we never heard anything else.
Well, if we're taking out vitals, we probably want to reduce the number of hours to 14.
I think you can pass this if you'll say 4 live, 4 online. Everybody will approve that.
We started that
Over 2 years, 4 live, 4 online. You okay with that, Jay and Jason?
I still think you're going backwards.
No, I nope. But
it would be Zoom.
Well, at least you're consistent.
yeah. Well, it seems we both are.
yeah, but we do have some consistency and broad agreement on counting commission meetings. Whether you attend in person or we can verify that you're at the meeting the entire time in this type of environment. What about the vitals? Okay. Let me treat that. And where we are on the vital statistics portion. Now, some would say that most, based on what my enforcement officers tell me, we get quite a few complaints regarding death certificates. And so, however, we could also say that a good number of those that do come to us, the licensee has complied. It's, the medical doctor, this or that, okay? However, she says,
Do you want to?
why take out vitals when a lot of complaints deal with death certificate issues? You want to elaborate on that?
I've got one case in particular where every time they submit in a amendment, it's on an old form, or it doesn't meet the right criteria, or they've resubmitted it and it gets kicked back. So I'm wondering, are there some people that need to revisit the rules with vitals or need an update and say, hey, these are the new forms. If you submit these old forms, it's going to get kicked back. All of this is causing more problems for the family because they're not getting that death certificate timely. They're not able to do what they need to do because this funeral home person is not able to do this correctly.
But there's also funeral home persons that do everything correctly and they keep mucking it up, costing us money and the family's delay. I'm waiting on a set of death certificates that were 6 months ago that are somewhere out there. And we still had to pay for a new set of certificates so we could get them to the family. So it's an oxymoron. Why do we have to fall on ourselves to follow their rules when they don't even do what they're supposed to do?
Are you talking about the Department of State and Health Services?
Yes.
Okay. What I think where Ms. Rodriguez is coming from is, to the extent that, because we are working with dishes, but to the extent that funeral directors actually know what they should do, those are the most common types of complaints we're getting And so I think from a common sense perspective, just of what we're seeing in the commission, it makes sense maybe to keep some type of vital statistic requirement in so that funeral directors and embalmers, to the extent that applies, are aware of the legal requirements. Now, the dishes, they've got their own mess and we're continuing to work with them on how to improve that. We've had to do some of that too, to put some better systems in place and communication between the two agencies. But in the sense of just funeral directors and embalmers knowing what their own legal responsibilities are.
Maybe an hour update of new things that are changed.
Instead
Yeah,
of
not two,
two,
because again, it's kind of like law. You don't need to beat a dead horse that's already halfway on the ground. But again, there's so many problems, but you need to worry about educating doctors and judges and coroners that are really messing it up.
The reason why the commission had vital statistics was because when it went into effect, there was a lot of problems in the beginning when things were going to TechSaver, the computerized system. The funeral directors were doing it. They still are doing it correctly. The ones that you get, I suspect, are very minor, ma'am, and I'm not trying to be disrespectful, but I think they're minor. What this man just said, the doctors are still not doing it online in time. The 10 days is not the problem of the funeral director. It's 5 and 5. And I submit to you, the majority, and you can ask people that own their own facilities that have to call and call and call. And you know what? The doctor isn't submitting that death certificate. It's the secretary or the administrative assistant. So I'm just saying that it's, that's why funeral directors are frustrated with this. And we think we know a lot about filing the death certificate and how to do it.
So I think this communication is great, because I think that would be something that we would want to know, and I think Mr. White would want to know, so that we could try to open up more dialogue with Vitals to kind of see where some of the problems are. But I also want to say, you know, like I said, I'm currently dealing with one who seems to keep doing this wrong and keeps having problems with their submissions. We're also getting contacted by the county clerk's office, who keeps on 3 or 4 different counties having problems with different funeral directors not submitting these timely. And so that's why I'm kind of wondering why we want to get away from having a continuing education on vitals, because it is so important to the process.
Well, it's
I almost feel like that's an ethics issue though.
Well,
It's not really a vitals issue, it's an ethics issue, and that could be discussed over in ethics, because when you meet the family, I do the death certificate with them in the arrangement room. There is no, if I waited 10 days, I'd have done forgot who they were. I don't know how they could wait that long. You just do it with the family. That's how.
Well, maybe
It's a great practice.
maybe we incorporate as part of the ethics requirement, some type of it needs to cover.
Yeah, vitals could
vital
be in ethics
statistics.
somewhere.
But just so you know, we have implemented internal procedures to just kind of check to make sure the reasonable.
So let's start. So let's start get a wrap on this. So we have some commonality on the counting the commission meetings online, verified, in person. Do we have broad agreement on the vital statistics requirement regulation? Just that requirement solely? Okay.
We could stop that, but we'll just bring it up with issues. That can be something we bring up in ethics or whatever we do.
Okay, all right. So we want to work with things, I guess, that would at least put us in a position where, you know, there's a broad-based consensus. But not to say that we should not continue going forward.
I mean, I like the idea of cutting down the number of CEUs that are required in general. But there are those people in the state and some online currently where we have discussed this in other stakeholder meetings in the past who have said, but we're a profession. We need to have that educational component because we're different than a trade organization. We're a profession. We need to show that we don't want to dumb down our profession by not having educational requirements. I merely point that out to give everyone in this room and those online who weren't in some of these meetings in the past, the history of why we've continued to have 16 hours of credit. At one point, there was a discussion of no CEUs at all in the state. And then we didn't even need to use the ethics one because we don't require any, we don't need ethics.
One way to potentially address professionalism in terms of that is like the state bar has a minimum CLE requirement. And then it has, if you get, I think it's something excessive, like 60 hours in a year, then you get to put a seal that says you're a member of the College of the State Bar of Texas, which then allows you to display that on your logo, that you have gone above and beyond the requirement for continuing education.
So that's like our CFSP.
Yeah.
That's like our CFSP, where we have to get many more hours than are required by the state. And it is a level of education and experience and professionalism that gets a seal, or I can use the acronym after my name. And there aren't very many of us in the whole country. There's a couple of thousand maybe. And in Texas, the last I looked, there were only 69 of us in the whole state that had a CFSP. So to your point, I mean, it's the same kind of thing. You can put a seal on your logo or use it with your logos or your marketing materials, or as I do, the initials right after my name.
All right, I think we know what lane we're in, and we'll show how the draft has changed with the commissioners so they can see that. And we'll just see where this all lands. Okay, let's go to House Bill. Oh, there you are. Okay, go back and go back to our front page there on the website and pull up House Bill 587. Yeah, that one there. And we just want to get some feedback from our stakeholders here. This was a legislation that passed during the most previous session. It relates to the incineration of a US flag or Texas flag through the cremation process at the request of any person. We did receive some suggestions, and you can bring those up. Thank you so much. And here are and we have two suggestions. The top third of the page is one suggestion. Scroll down there a bit. And there was another suggestion. Okay, and this is a very interesting bill. Okay, it did change a lot even as it went through the legislative process. So we know some of you obviously have crematories, you have your retorts, and just wanted to kind of get your feel on this. I would call this a permissive bill, meaning if you don't do it, you don't come under the the purview of this bill, okay, of this legislation. If you decide to do it, then you come under this legislation. So, you know, we did kind of get around with a few folks and asked them to send us some ideas, and here's some ideas. So the suggestion up top is very prescriptive if you decide to provide this service. Another suggestion was to just stick to defining crematory, what should crematory sanitation should be, that's in the bill. As it relates to releasing flag remains to the proper person, they said it doesn't need to be any more stringent as releasing human remains under 716.156. And disposing of flag remains, again, the suggestion is it should not be as stringent as disposing of human remains in 716.302. It's a bill. I mean, I'm a different situation. I just enforced it. Okay. I won't write them in.
Well, I do offer this program.
Okay.
Advertised. We encourage the community to bring in their flags that need to be disposed of. I'll refuse one that is not at that state just because that, unless it's a family saying this was dad's flag on the front porch. And from my viewpoint and from my staff viewpoint, I mean, we in part of our cremation paperwork, we announce this program, so it's up front. You've got a decal by the front door asking people to participate. I'll have people that when we go through that we're cremating their deceased, they'll show back up in an hour after leaving the funeral home. Here's the flag that we had. Can you use this for dad or mom or brother, sister, whatever? And likewise, the people that bring their flags in are hunkering to participate. And we do it just strictly for veterans. It's just, I've just seen so much emotional support, both by people contributing flags and by those that know a flag is going to be placed on the whatever container of there. And we present it that it's disposing of the flag by incineration, as the flag code enforces. It's honoring the deceased, their service, and it's allowing the flag to have its last duty of honor. That's the way we present it. And it's very wide community driven. I actually have more flags than I know how I'm going to get rid of, because of the recognition of the program.
So what procedures do y'all kind of follow just to kind of help us as we're in this rulemaking process with, because per the new law, we have to establish guidelines on crematory sanitation, the release of the ashes from the flag, and then how to dispose of ashes from the flag. So what are just some?
I look at the flag and being given to us, so we're a new proprietor. But I don't see any reason that I have to have a permission of somebody to use that flag by the way we present the gift. From my training, I've been through the courses. I don't press buttons at crematories, but what's left of a flag?
Nothing.
So I don't see where the sanitation issue. We have been by the crematory to cut the brass rings of the flag because that is an issue. So we cut those off and those go in our recycle bin for the city. The only thing I can think of is maybe that we get an initial or liability release from the family acknowledging that it's okay for us to do that and just not go on their enthusiasm if they see it down in print.
And I think what's important about this, as far as Phil, and I alluded to this when I was asked to testify on the bill as a resource. You thought that was what was already in statute. Is you're doing this before this bill.
I'm following ethics.
Yes.
What I feel, the flag is very important to me. I'm not military. I'm one that bitches, the American flag belongs to this side of the state, idiot. So I just following ethics, honoring the veteran, helping the family in a grieving process, and doing what's right for the flag.
And you believe you have this discretion without this legislation?
Correct.
And that's what I felt, because somebody thought that investigators were going out, rounding up complaints. And I said, look, I don't know of any complaint that I had, and I said, even in, I believe, 716, about what, you know, the remains of what can be in there, it says, or any other material. So I said, if this came to me, you know, my thought would be, well, it's any other material, so, which could be a flag. So, but look, I get it. You gotta go back home and talk to the Lions Club. You gotta have something that you did last session if you remember. Yes, sir.
Hi, Gary, do you cremate flags on their own?
No.
Okay, so so what he's doing is cremating the flag of that person and honoring that person and that flag in that particular way, as I understand, am I right?
It's a ceremony that's different from the Boy Scouts, the American Legion, as they don't have a body involved, and I'm not doing the worded ceremony.
Okay, so the legislation that was enacted was different than that. It was about standalone flags and cremating one or more American or Texas flags in a crematory on their own.
Okay.
And so that's different from what he's doing. He has every right, the family, to cremate that flag with that body as prescribed by our already rules.
Right.
This would be new or potentially new, and I think it's simple. It can be done.
Okay.
You do it at a time when it's separated.
They have the times here.
No, I'm saying, but it's separate, the cremation itself is separate. No human bodies or anything else can be with it. It's separate. The crematory is sanitized by their usual process. It's sanitized after every cremation anyway. And that whatever's left is dealt with in the prescribed way the legislation states.
So who brought this up? Where does it come from?
Well, I think the member, as I was briefed, Representative Patterson, you know, Boy Scouts folks would show up, and because flags nowadays, they're not totally cotton anymore. They're made out of these synthetics, which give off this is what we're told, give it off a very bad fumes, not good, and that maybe these need to be handled in a retort. And according to the bill author, crematory owners said, well, we need some legislation to cover us, make sure we don't, you know, get into a situation. So this is what this is.
Well, because we had like the VFW was like, would you mind taking a couple flags for us? I said, come on down. They backed up a truck.
Okay.
A whole trailer, like it filled the whole, and I was like, what do? I can't tell them.
We're talking about like little parade flags.
Like even the little wooden like parade flags, I just truck. They said a few.
Supposed to be fulfilling. That's where it gets sideways with us legally.
So
Chris Farmer.
Mr. Farmer.
Yeah, hey, I just put this note in the chat. I just want to make sure, because I've always taught people when I'm doing my crematory certification training is, you know, you shouldn't put anything in there that you're not licensed for, obviously. If the law allows for it, that's great. I'm all for it. I think it's a great service. I have people ask about all the time. My concern is because that the way that the TCEQ regs are, I'm kind of looking them up right now. I haven't looked at them in a while. I want to make sure that if we are contemplating a standalone burning, that it's not going to, as an unintended consequence, change the categorization of the incinerator into away from the crematory.
To a human body incinerator.
Yeah.
Right. I don't want it. I don't want us to accidentally fall into that. You know, as
the waste.
a consequence or violate somebody's permit or something like that.
Like we can't burn a bunch of files and different things like that. It has to be
Correct.
for dead human remains. and whatever's with that body. It can't be a pet either. So I
Because
mean, you're
otherwise
right.
you go into the definition of a commercial
not.
incinerator.
Mhm.
Yeah. And I'm confused by the statute. I'm reading it here.
Yeah.
And it seems I thought this was incinerating a flag with the body. So like you have a veteran and you drape the flag over the veteran and you incinerate the flag just like you would do a coffin, right? You drape it with that. But this seems to contemplate only doing flags and only doing them during the week preceding and the week following Memorial Day, Flag Day, and Independence Day. Do you already have authorization to incinerate a flag draped over a body?
We can incinerate whatever's with the casket. It just can't be another body or a pet.
So this is a standalone incineration of flags contemplated for a Memorial Day remembrance or a Flag
Properly
Day or
disposing
Independence
of-
Day remembrance, only on those 3 days or those 3 weeks a year, it looks like.
Yeah, it's a way of incinerating retired flags. I'm trying to use the right word.
Irrespective of
There's
for
no
a
human,
veteran.
right, there's no human body involved. It's just retired flags.
But what Mr. Farmer's bringing up is an excellent point, that
Yeah,
then
it
you're
is.
changing the use of your retort. Then you might end up in a position that you can't use your retort for human remains because of another rule or law out there.
I think he brings up an excellent point that probably the legislature didn't think about.
I think we can coordinate with TCEQ too on that and just kind of work with them. Cause it could be if it's something.
Let's just, no, I don't think we should do that.
Like Harry does, it's great, and that's fine if we do something similar. But specifically saying that we'll use our machines for just flag disposal, I think we need to steer clear of that.
I think they're just probably running into a problem. What do we do with all these retired flags? And maybe they're trying to have us be the one to
Where
help
they-
them, and they need to figure out their.
They can hire a cemetery and bury them
Yeah, yeah.
and let them just kind of
Yeah, 'cause
disintegrate,
nobody
open the
wants to
grave
foot the
again and
bill
bury
what these
more.
flags will cost, that's
But-
probably cremate.
We shall adopt a rule.
Yeah, yeah.
I mean, we don't really have that discretion. The legislature has told us we shall adopt rules to implement this section.
However, we can say it's at the license holder's discretion.
Which it is. And I just went through here. I don't see where TCQ showed up as even as a resource. Okay, so as usual, this is better. And definitely make it known that it's a discretion. Okay.
And maybe the concern about it changing the category.
Yeah.
But that.
Yeah,
we're
the
concerned.
TCEQ.
Yeah, cause it could change
When this whole thing came about.
Right.
Also, where the veterans were coming from was desecration. And I don't see any of this, as long as it's explained,
Okay.
desecrating the American flag. In our little community, we have a special service once a year where flags are
Yes.
burned and disposed of, and there's a certificate and a ceremony. And we burn them out of doors, and as long as there's no means, and I don't see it in the bill, and I know what Mr. Farmer's saying,
Mhm.
I don't see that being a problem with
And he has his hand
the
up.
industry.
Mr. Former.
Yeah, thank you. So just if you go back and look at the TCEQ regs on non-commercial incinerators and crematories, it's very specific to what it can be used for. And so, it doesn't include other things like this. And so I'm afraid that it would. The only way I can think of, if by following the legislature's mandate to create a regulation on this would be to say, like you said, you may do this, and then maybe just insert a caveat saying, unless such action would, violate the TCEQ regulations.
So the other thing too is, statute does trump rule. And so what I can check too with the TCQ is if their rule, cause I know they also do a lot with the EPA, but I'm sure this is where we're talking about the United States flag and the Texas state. It's not just any old item. And so there is a particular symbolism and probably some certain things that have to be followed both in federal law and state law. So let me go ahead and I'll reach out to TCEQ, see what they think, see if they're aware of any laws. And I can also reach out to the Veterans Commission, see because I'm sure they probably had.
you say that one statement again, Mr. Farmer?
Oh, I was just saying, yeah, I was saying that, you know, you could say, as you guys were talking about, may cremate flags, blah, 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 et cetera. Unless such action would, you know, violate TCQ regulations or
Yeah.
something like
other law.
Right.
because I don't think it's, I mean, I'm not sure if it's impermissible. It's just that, so right now, you know, funeral homes get or crematories get the permit by rule from TCEQ and without having to go through all of that exaggerated process. And I'm afraid strictly that this would take them out of that. And then they would have to, you know, be a incinerator, you know, for other purposes. And it is an unintended rule. And yes, statutes trump rules, but you know, they could change the reg on this, or at least have them fall into the category of a commercial incinerator without violating the statute, because the statute doesn't say that they would still have to remain, you know, human crematories. So I'm paranoid. That's what I do. I kind of see all the problems that can.
No, this is.
You have a reference for that?
He put in the chat.
Yeah, I just put it in the chat
A
box.
pet incinerator is different than a human incinerator. Pet incinerator could possibly be used for that.
Yeah. One other thing I noticed at the end of the statute, it says that we have to, by rule, ensure the incineration is in accordance with 4 USC section 8, chapter 3100. So I looked at 4 USC section 8, and it just says it has to be done in a dignified manner.
Right.
So that's easy. The issue is that chapter 3100 is very specific about how it should be conducted in terms of doing the ceremony that you talked about. It's not a must, it's not a shall, it's a should. So it's still optional, right? But it said that the retirement, it goes through the retirement ceremony. And so we might add another line that says, just to draw people to chapter 3100, because it says we have to ensure that we would just say that any ceremony conducted in conjunction with this incineration shall be conducted in accordance with chapter 3100 government code.
Okay.
And 3 USC, what did it say? Just copy the statutory language.
Right. Well, and then another thought I had too, and for those who cremate, if you want to chime in I mean, and I think this is kind of one of the proposals of what if we just go ahead and say any cremation of a flag must follow current cremation procedures for decedents. I mean, I know it's stricter than other objects, but would that help?
I think it's a different type of cremation that we're talking about
Okay,
here.
right.
Because
Okay.
veterans, sometimes the family chooses to part with the flag because the family's usually given the flag.
Right.
And they've made that choice.
But I mean, in the event that they choose to part with it, if we just say, okay, the family's authorized to part with the flag, excuse me, for cremation, so the embalming facility just or the cremation facility just has to follow whatever procedures it uses for.
Well, the crematory operator would typically do anything ceremonial.
Okay,
Yet the funeral director would be in charge of that.
I see. Okay.
Because that falls under them being in charge from the first call to the disposition, cremation being that.
Okay.
But they do flag folding ceremony. I don't think we follow 3100.
So would there be any documentation that would need to be acquired to cremate a flag if it's a standalone flag?
I think it would be good. Maybe kind of like cremation
Just a
authorization.
consent, a flag cremation authorization? Does that have any relevance?
Well, but it says that in the rule, that the person will sign a disclaimer, but wouldn't that be the documentation?
Yeah.
I feel like
That's
the
for,
cremation
that's
authorization,
for
it's pretty hard.
like the flags be.
Yes. Okay, so we have a few things we need to do, as far as the language. We don't need to make this overly. Obviously, we need to ensure that our licensees know this is their discretion.
Required to do it, and we just point them in the right direction.
That's right.
So they can get their own advice.
That's right.
Specifically safety and
Okay. We have just a few more left. Do y'all want to take another break or continue to charge forward? Charge forward, okay. Funeral director in charge. That's when we talk about. Funeral director in charge, specifically Rule 203.22. During our stakeholder meetings earlier this year, there was some discussion about when the funeral director, what's the requirement of the funeral director in charge being available for routine functions. Okay. And there was a thought of maybe putting in the term generally. Okay. Then there was also a stakeholder suggestion that the FDIC identify their primary location. And so
don't you do that on the form anyway? Every funeral establishment has to designate an FDIC for that establishment.
Okay.
But some can have one director at two establishments.
So which one is your primary?
Yeah, because what you are trying to figure out is if one person's covering 25 funeral homes in a 50-mile radius, right?
Yeah.
So
We at least based on the forms that come in, we determine that along with
okay.
Mr. Bass.
And this is also going to work as the embalmer in charge too. It's going to be the same thing, right?
Then 50.
Right.
Is it?
It's 50 miles.
The 100 is that's right, okay.
Yeah, so, I mean, there's a lot of different loopholes on that.
Yeah.
He finally speaks.
That's like,
You calling us?
My locations are all 80 miles apart. None of y'all have that problem.
This is Chris Farmer. Sorry, I tried to figure out how to raise my hand. Couldn't figure it out, Jay. You talk about identifying a primary location, but there's no other reference to a primary location anywhere in the statute that I could see. So I'm not sure what the significance is of that. Like you said, whenever you change your FDIC or whenever you appoint an FDIC, you have to list all of the other locations that individual is designated as an FDIC at. So the TFC or the Funeral Service Commission knows who they are, where they're at, and they have to have it approved prior to so that all of the other requirements are met as far as the number and the distance and all of those things. So I understand I guess I don't understand the intent of having a designation of a primary location because it has no definition or no other meaning within the statute.
Oh, well, y'all don't want to know my real opinion. Because when I was looking at this rule, I'm not sure what the statutory basis is to be able to be an FDIC or EIC at more than one location. Because based on the definition of funeral establishment, and there's no express statutory authority that says an FDIC can be an FDIC at more than one location. There is definition of what the FDIC's responsibilities are. So I would say as long as the FDIC can, in good faith, carry out those responsibilities for each location. That was what came up to me as I was looking at this draft. So I didn't get one because I was stuck on that legal question.
Well, I think I may be wrong and I don't have the citation. I think it does allow for FDIC to be at multiple locations because there is a distance requirement related to it.
I'm sorry, can you speak a little louder?
Yeah, I'm sorry. I think that and I don't have the citation in front of me, but I'm pretty sure that there is a provision that allows an FDIC to be at multiple locations because there is a distance requirement associated with it. So I don't have it here in front of me and I apologize.
And you're like, I'm open to I just could not find, because I did a Control F on like the mileage requirement, and the only thing I saw on that was for the preparation, is it the preparation room exhibit? And that's why I was just trying to find out what the origination of these statutes were, because maybe it was already contemplated in that, because again, I've only been here 5 months, don't know anything about the industry, so I am open to. That's why I wanted to bring this up for feedback, because it's just, again, based on just plain language.
Yeah, and I think the other, yeah, I understand what you're saying, and I think the other point that's important to know here, is that, you know, a lot of times locations are not fully staffed or fully active. And so I think the intent, a lot of these is to have, and I think, you know, a lot of people on this call can tell you, you know, you may have 5 locations where you may not have, at 3 of those locations, you might not have anybody there anytime except for once a week when someone comes in for a service. And so they're not capable of having one FDIC per location because they may not have that many funeral directors because they don't have services there. So I think the concept of an FDIC at multiple locations absolutely is essential, especially when you got, you know, whenever you live out in the dusty West Texas, some of our friends on this call. So, you know, it's one of those things I think is essential, and I'll try to find the citation for you.
No, I appreciate that. And I know that's what Mr. White and I had talked about was that concept where maybe like, except for we used East Texas where, and like maybe they were just open one day of the week. And then and then 100 miles later, or however, whatever the mileage is, you know, the other town. So, and I totally understand that. I think too, it's just as long as the statutory responsibilities of the FDIC or EIC are not being compromised. But I guess that is the question. What is the primary? How would identifying primary help?
3.22.
They should have to file an exemption, right, for that?
3.22.
This is Carissa. Can you guys hear me?
Yes. How you doing, Carissa?
I'm great. This is my comment is coming from, I've had our legal folks look at this and I agree with Chris. We do have some folks that spend, you know, equal amounts of time at each location and they don't have a primary location. So that's our concern, is that this seems a little narrow and too strict. So that's my 2 cents here.
Could they just get an exemption? Because I think the purpose is to prevent people from doing something shady.
Right.
So of course, people with a good explanation of why they can't have a primary just gets an exemption.
Right.
But because what we're trying to step away from is someone who's not even there.
Right.
They're using the license and all these, that's the scary part that we're running into.
Right.
So I think
But that's also the risk that licensee
Yes.
runs, because it's a serious thing when they become an FDIC. And they know that means they could easily have their license revoked.
Would
Yes, before any other director.
make a difference to what you were just commenting on, 2 weeks ago with the cremation folks or in New Jersey or West Virginia or whatever, and alluding that they're local? Is that anything that this could help maybe prohibit?
Well, I think in that instance, that was up in North Texas, right? Yeah, I think in that instance, and we have had these discussions and these out-of-state folks that are operating in Texas on a website.
Legacy cremation and heritage.
Yeah,
cremation.
birth song,
Right.
tulip.
And so I think one solution to that would be, as I was just listening this summer, would be you have to be connected to a brick and mortar. Okay, I think that, at least what I'm hearing from licensees across the state, that would probably be a statutory change.
Right, but I didn't know.
But this here, I don't,
Forcing the funeral director more locally.
I don't think this would, or what we're discussing, you and I would really address that, because this is some entity out of Colorado calling up Sid for says, hey, go down here and pick up so and so. And the family is confused on, you know, they probably sent money to Colorado. Then Sid sends them a note to pay for the first call. No one knows who these people are, and they are doing the work that you guys are licensed to do.
Well, the reason I asked is
Yeah.
that, like you
Good
said, I
question.
don't see any sense in changing this
Okay.
unless it will prohibit
If it's
some of
that,
this
okay.
cremation crap
Okay.
that good people are having to put
Right.
up with.
It's big, it is a big mess.
How your reference to exemption is prep room exemption only, right?
Yes.
Okay, I want to make
And
sure.
records
Okay.
exemption.
But I think the primary can have an exemption, like you have a primary location, but because of this situation, they're exempt, so they can be over a couple of locations because we know it's legit. Is that something that we could do?
Well, The executive director would say, our rulemaking discretion is granted to us by statute. Question is practical, yes, is it practical and that sort of thing? So, this was just brought to us and we're just laying it out. Okay, we kind of touched up some language for you to look at. At least the staff here, we're not necessarily rooting for anything.
Just says to identify their primary location, right? So you have to identify your primary residence. Is there?
Again, I think the question you have to ask is practicality and efficacy. If you have this, what changes? Okay, I think on our form, it'll be a form saying primary, Coleman Mortuary, Woodville, Texas. Okay. What changes? I think that's one question you would ask.
But what improves?
Okay.
So maybe
Yeah.
the people that are online selling cremations, then if they lease a little office somewhere in Texas, they can say that's our primary location. But it's not licensed.
Yeah. Usually what's happening, they have a website.
Right, we saw that got reported to us.
And they're directly communicating.
Texas consumers.
Our
Yeah.
Texas consumers think they're dealing with a funeral home in Texas, and they're not.
Yeah.
And then this online group starts calling funeral providers to go pick up the body. They don't even have a contract with anybody.
They're pretty much just doing affiliate marketing, just outsourcing the entire business of the funeral establishment.
Right. Caressa?
Craig has his.
Oh, Craig. Chris, okay, Chris.
Thanks.
took me a
Well,
while.
not speaking directly about any of those providers that were mentioned that are out of state. I mean, those people don't have FDI, they don't have any funeral directors in Texas that
That's right.
that are working for them. And so this wouldn't affect them at all because they don't care. They're operating under a model of, hey, we're not, we're in Colorado and we're funeral directing in Colorado and we're contracting locally. And so the question, in order to crack down on something like that, it would be, and I know other states have done this too, is they say, if you're talking directly to families and you're setting up funeral arrangements in Texas, that's completely in Texas and no connection to Colorado whatsoever, then you are funeral directing in Texas, and therefore you are breaking the law in Texas. So I haven't seen any of these cross-state operators that are, questioned do anything licensing in the state. They're flaunting that they're not.
It's enforcement.
Okay. All right. No more tweeting on this one. Okay.
Your investigators know who the bad actors are.
As soon as you go in Spain.
Okay, the next one, procedures and criteria for inspection of licensed facilities. Earlier there was this year, especially when you look at Rule 203.44. A4, it says inspectors shall use reasonable efforts to conduct inspections between the hours of 8 and 5. But a licensed entity is required, but a licensed entity is required to be open at all times for inspection. So the thought was, the concern was to be open at all times. Okay. And probably the challenges with that, especially when you're saying you can get you some credit hours for coming to a commission meeting. And I guess Kyle shows up, okay, while you're up here at the commission meeting. And then on 203.44A5, sort of the, what happens if you're not open during these regular hours, how do you move forward there? So there's a proposal there, okay? And,
I like the language. I think that it is strict enough, yet flexible enough that I think small funeral home establishments can work with this.
okay,
I mean, if Kyle or one of his other friends knocks on my door and I'm not there, it's incumbent of him first to try to contact me and see where I am and when I can get there.
okay,
And I like that idea. And then I'm notified that somebody's trying to come and inspect. But maybe I'll be there in an hour. And so he goes, grabs lunch and comes back. Or maybe he comes the next day, whatever. But the fact is that there's good language here that gives some discretion that you can't be dinged because he came at 5 minutes to 5 on a day when we're traveling back from a funeral service commission meeting and all of a sudden our license is in danger.
okay. And just for clarity, this, Kyle hasn't done that to us.
No,
Oh, okay,
I'm just
okay.
I'm just using his name because he happens to be sitting here.
But it's just going through the rule review and looking at the certain, and.
This makes it more flexible,
Okay.
still strict, but more flexible for the smaller operators who are not gonna have staff in their office 8 or 9 hours a day, 5 days a week.
Okay.
And it puts a timeline on it, because if they come twice during 6 months, then you could be in trouble. I mean, I have a timeline.
Right. But even there, you could be in trouble, but you could be writing a letter to the executive director said, but on this date, I was at this funeral and here's documentation to prove that. And on this date, I was at this funeral and here's documentation to prove that. And it just happened that an inspector came to my door twice in a 6-month period when I was at funerals. Hopefully those weren't the only 2 funerals I did during that time period.
Could be.
But could be.
Could be.
Don't come to Van Horn.
Right. So I think that y'all have done a good job on fixing that rule.
Interesting. Say interesting for a lot of reasons. To give such a ringing endorsement for you, I gotta just look around and make sure there's nothing else out there, no other.
Check with those guys up there.
Yeah, anything online?
There's 8 new messages in the chat.
Yeah.
Like, so.
This is Carissa. We like the suggested revisions to this. So, good work.
Other ringing endorsement.
And the documented reasons, you think that's enough, that nothing else needs to be added?
I mean, it could be any. It could be. They went to their own mother's funeral. I mean, it doesn't matter. It's just that you are out of the business conducting funeral home business somewhere.
Okay.
Maybe just add a catch-all at the discretion or other valid reason as approved by the ED or something.
Instead of conducting a funeral service, attending at the funeral service.
And your inspectors know these guys. Some of them are volunteer firemen, some of them the coroner, some of them the JP.
Some of them are late,
You
some
know,
of them early.
Okay.
now,
You got it.
granted, I don't live in East Texas where they're only 20 miles apart. Maybe they have 4 locations within 60 miles, and I'm
Right.
sure that some of those locations only do 1 funeral a month, maybe. And it may not be open until the next month. I'm sure you take that in consideration, don't you?
Absolutely.
Okay.
Little common sense works a lot,
Yeah,
right?
but there are new inspectors and they were
Train
probably
'em
going
up.
to Van Horn before they went to Midland. But I can't help that. You can't. help that.
Well, maybe they
But-
want to go out and see the Bezos rock.
Okay.
Attraction out there.
Okay, so, point well taken, Commissioner. And, we'll tighten that up on the attendance at a funeral service? Okay, we'll tighten that up and.
As long as it's not gonna be an excuse of, oh, well, I happen to be attending Joe
Well,
Blow's funeral, like
yeah.
just.
We have ways to audit it, or we could keep it there and then go to F. At the discretion approval of the ED, you know, have those discussions. Okay. Let's look at 203.5. N is a November 3 provisional license examination requirement. And we sat down, had great discussions with so many people, even down in San Antonio, and about the provisional exam. And the thought was, you know, a scenario that was brought to us was, you know, a mortuary college student may take the exam as part of their mortuary law course. Maybe it's this final exam, taking the MLE. So they have went on our portal, they have bought the exam, they have taken the exam, and they have a score. Hopefully it's a passing score, okay? But they're not ready to immediately go into, within 6 months, to go into that provisional program. And if that's under current rule, they may have to come up with another $89 and retake the exam. So, and some schools may actually pay for it, you know, to get, you know, to get them on to take the exam. Okay. So the thought was to take that to 24 months. That was a suggestion. And also the situation where someone probably starts off as a fully licensed active funeral director. They have their mortuary law degree, but they just start off just as a funeral director. 4 or 5 years later or more, they decide, hey, I want to do the embalming. So they have to do the embalming provisional. Okay. And the question would be, would they have to retake the mortuary law exam? That came up as well. So there's just some suggested language there for you to look at.
I mean, if you're practicing in one of our 2 licensed professions and want to go ahead and grab the other licensed funeral profession, I mean, I don't see, if you're continuously practicing in the state of Texas, why you would need to take the mortuary law exam again. I mean, I just don't understand the rationale for that.
So need to clarify. Like they've already gotten maybe they've already gotten their provisional active funeral director license, but they haven't applied to become a provisional embalmer license. So do we need to add not just where it's an active funeral director embalmer, but also or provisional? I'm not sure on the licensing part. I just want to check.
I think it's fine the way it is.
Okay.
24 months is a long time.
Okay.
If you're a funeral director and you want to be an embalmer, people already know you
Okay.
get busy while the stuff is still fresh in your mind.
Okay.
And get it finished. I think 24 months, just like you read that, is fine.
And it says may not require, so whose discretion is that? May not require. The commission may not require.
Okay, I see what you're saying there. You would suggest?
No, I'm just,
Oh,
I'm just
okay.
asking who would make that decision at the commission?
Okay. This probably, if that would be the language, probably needs to be a shall not require.
Yes, but I think to his decision, like who would an agent, I think it would just be
Somebody's gonna make a
administrative.
decision to require an exam.
Yeah.
Who would that be?
That would be the, you know, on the front line, our licensing specialist. And to determine when.
All I'm saying, I'm good with that,
Okay.
only because it says someone's gonna look at it. They
Right,
may
yes,
or may
yes.
not require.
Okay, yes,
Can make it a shall, so that it's not an option.
yeah. Yes, ma'am.
Oh, I was at the stakeholder meeting where it came up. I think the flexibility of it is good. I mean, somebody may have a reason why, but I mean, then this kind of goes back to our continuing ed where we're saying people need a law update. So these are students. And I think that, you know, maybe keeping that flexible may
Okay.
just a flexibility, because that's what they brought up was that the students said they get 6 months and they haven't finished their apprenticeship. They did the law exam, then they're going back and taking the law exam again when they finish everything else because it expired to 6 months. That's what came up in that meeting. And I think the apprenticeship lasts for 24 months. So it was the students that brought this up. That's
So
what
why
the
doesn't
24 months.
the license last 24 months?
The law exam, right?
The law exam.
Yeah.
Right.
Because if they pass the boards, those last, they're like, can this one just last? And then in 2 years, in 24 months, they're gonna be taking CEs hopefully, or they'll be reapplying for an apprenticeship. Because
Yeah,
that
they're actually
expires
going
in
into it,
24
yeah.
months. So it just kind of gets everything kind of in line and they're not worried about, oh, 6 months, I have to go pay to take that test again. And I'm not even finished with my apprenticeship.
Do you have any historical perspective on this? And I think that came up too, that, you know, has it always been?
No,
Okay,
believe that it changed in like 2008,
okay.
the 6 months. It used to be 24 months.
And there was a historical point there. Anybody online?
I'm not sure really, but it changed it to 6 months.
Well, when they changed how many cases, instead of 60 cases, 40 cases, and
yeah,
instead of mailing your
25.
cases every month, you just sent them at the end of the year.
Yeah, that was in, that change took place in 2015 when we went from,
2015.
this was changed, I think, and we went from 60 cases to 45 cases, and there was some pretty substantial changes in the provisional program.
Right.
Right.
And you don't see this inconsistent with those substantive changes, do you, Jason?
No, I mean, I think it, what's the best way of doing this? And I think that this 24 months is probably the best way of, being able to handle this.
Okay.
To complete the program.
Okay.
And you don't want to put shall, because that means you can go 36 months, there's no.
Yes, ma'am.
I have a question or clarification. So would that mean that if a provisional funeral director applies, 6 months later, he applies for the embalmer, would that test actually be granted to that embalmer for that 24 months? Or is it applied to just that license?
The provisional embalmer or regular embalmer? Like, is that person applying for the provisional embalmer?
For the provisional embalmer.
That's why I was wondering if we should put in provisional license in there, because we have someone who might. I think with one of the situations Marina had talked about where someone had already gotten their provisional funeral director license, but after the 6 month period, decide they want to pursue the provisional embalmer, but they still had to retake the mortuary exam.
Right.
Still.
That will cover both, or just that assigned to that provisional funeral director?
It's tied to the applicant.
Yeah,
not to the
that time period. Yeah, that time period, yes. Okay. And also, I think this would provide a needed clarity for licensing staff as well. This will, okay. Okay, next one, I don't see any other hands up, anything in the chat about this? Okay, all right. Provisional licensee, direct supervision. And we're primarily looking at Rule 203.5 in the provisional license. And there was a thought that maybe a more seasoned provisional licensee, there would be a requirement for the FDIC or EIC to be on the property. Okay. And not necessarily, I think you brought this up.
Yeah, I brought this up because, student nurses, student counselors, that they've already been through the program, have taken the boards. Now they're serving their provisional period. Isn't there a point in their provisional period that the direct supervision can be assigned off to say, all right, in my opinion, and because my license, you're working under my license, I feel like you can go forward and I don't have to be in the room with you, but I will be on the premises if you have any questions.
You have to be on the premises.
You have to be on the premises.
So it's more of a language issue. It says accept a funeral service. And I'm wondering what the rationale for that is, and
I just threw it in there. I just threw it in there, so see it, that's all.
no, seriously, I mean, because some funeral services may well be on the premise of a funeral home.
Okay.
Some funeral services, such as most of mine, are at a cemetery. And so that's why I wondered what. It just caught my eye. I didn't understand what we were trying to do there.
Yeah, go ahead, Ms. Hartsville.
I'm gonna backtrack a little bit before, going back to Mr. Valley with so section 651.303 says that a provisional license holder may work only under the direct and personal supervision of a funeral director or embalmer as applicable. I know I did some legal research just to kind of see how that's been used in other places, and usually if it's direct supervision, it can be expanded to premises, but usually when it's direct and personal, it has to be within the
same room.
purview, of the
Shoulder to shoulder, so to speak.
Yes, sir.
And there have been some, one AG opinion that has probably suggested, Counselor, I don't know if it's in that part of the statute, but there's another part in the provisional statute where it says the commission comes up with the rules of the provisional, and I believe there's, and I believe there's a spot there where it says, and, providing the provisional licensing opportunity to work with less supervision, something like that, okay? And that as you get more as a provisional, as you get more experience, you kind of graduate a little bit.
I like this idea.
Wait, I'm not opposed to the idea. I just.
Yeah, no, I'm always thinking about that AG's opinion, okay? That 651.3.
303.
Okay. Okay, 303. The commission shall prescribe and supervise the course of instruction received by a provisional license holder while participating in a provisional license program. In A1.
A2 says direct and personal supervision.
Was there so?
I think you found it. I don't think I got that. I was just looking at some other.
I think it is. Oh, that's that a personal supervision is in the same.
And I think that's why it uses that phrase and not just.
That's why you just what you just read too. It's not in.
Okay.
Facilities.
So in that 651.303, you go to D. 3. Establish guidelines for supervision under which a provisional license holder is granted increased responsibilities during the course of the provisional license program. Yeah. So you could still do increase, someone would probably tell me, well, James, you can still have increased responsibilities, but it needs to be shoulder to shoulder. Okay, okay.
Right. I mean, you could move them from sitting at a table with you and watching you do the arrangement. For them to, you doing the first half of the arrangement and them chiming in with some merchandising arrangement questions for the family. So they're getting a little more comfortable working with the family. And then later on, as they maybe get 25 or 30 cases and arrangements, that you can say to them, okay, this is your family, this is your arrangement. I'm right here with you, but I won't step in unless you're knee deep in quicksand. And do that. And yet you're still there directly supervising them, but they have increased responsibility.
Okay. So, you think you just need to treat this more? It's not something you probably be able to litigate right here, right?
Correct. I just want to do a little bit, again, I'm not opposed to that idea. I think it's a
Yes,
good idea. I
right.
just want to make sure we've got the statutory
Yeah,
protection.
and there's an AG's opinion out there. I think that was Cornyn, or it was another one, and Cornyn kind of came back and regurgitated it.
Right, I think there were actually two.
Yes.
The first one and the second one
I think the first one was
affirmed one.
Maddox, and then Cornyn came up with one and kind of.
And just said, yes, he is correct. He affirmed
Right.
the original. And that meant that you had to be in the same room.
Right.
Right.
Now, Bill, what I think going
It was
forward,
last-
yeah, I think going forward, maybe if you had a good member of the legislature to take a look at that, because there is that term direct. Okay, and then that clearly probably gives us a landing path on some type of language like this. Okay, let's just let,
There is
You know,
found-
something
exactly, found it. So there's a 1998 OAG opinion, right, that says, oh, well, of course, I can't find it, but bottom line, because of the use personal supervision, it has to be in the same room, not where it, so, kind of what Mr. White said, I think it would need to be a legislative change, and maybe if it wanted to be direct and then give commission rulemaking authority to say, like, maybe at the beginning, it needs to be directed and personal, but if they, in the context you have provided where they complete everything, they just do their casework. It's up to the discretion of the commission to make rules to allow for just direct supervision where it's on the premises. Or
Or
something.
maybe like the last 10 cases or.
Yeah, something.
Not in the room.
The licensing gate.
No, it would be a good idea,
okay,
because I know in 2015, when we made substantial changes from the 60 cases to 45 and some of the other things that came along, you know, it's kind of like continuing education. Well, why do we have 16 hours? Well, you know, my first question was, why do we have 60 cases that are required? And nobody could answer that question. And so we started looking at other states and so forth to see, you know, what some of the other states were requiring, and that's kind of started the process. And I may be interesting to look at what some other states do. I know in Oklahoma at one time, if you had completed 6 months of your 12-month apprenticeship, and it's an apprenticeship there, then your supervision, the actual licensed funeral director, the supervisor, had to be within a 3-hour drive, I think, of the funeral home and be available by telephone. All right, that's going back a little ways, but they recognize that probably at the 6-month period, you may have some experience under your belt and allowed the apprentice at that time to do more. Certainly if the supervisor felt that was, you know, that was appropriate. And so I think maybe you're on the right track of looking at, you know, I know that the statute language needs to be addressed. And I do know that, 1998 was, I think, Dan Morales, I think I have that letter here of his opinion on this. But I think it's worth looking at to see, are there some other states, things that might be working there, to see about, granting a little bit more autonomy to the provisional ones.
Okay, go ahead. Hey, wait, Jason, are you finished?
I am.
Okay, yes,
That's
Colonel.
why, one of the reasons the commission did away with the oral boards. If you've gone to mortuary school, passed the board exams, done cases, why do you need to have an oral board exam, as an example? I think this is
okay.
very sufficient.
Okay, well, I don't think the current Attorney General is gonna come and drag me out of my office, but, just in case he doesn't, let me just let, Sarah treat it. And, we may have to go the legislative route, okay? But, we definitely want to make sure, we wanted to protect, your liability and make sure that, hey, this is someone that you can at least think about. Yes, ma'am.
The 1998 opinion also deals with the D3. Because it says, your request suggests that a provision directing the commission by rule to also establish guidelines for provisional licensing supervision, under which a provisional licensee is granted increased responsibilities during the course of the program, gives the commission the requisite authority to have it where it's just direct supervision on the premises. The OAG's office says we disagree by its term. This provision authorizes the commission to prescribe guidelines for supervising increased responsibilities assigned to a provisional licensee. It does not speak to the meaning of personal supervision specifically provided in the act or permit the commission to change the meaning by rule.
So you would say?
So I would say we can't do it without legislative change.
I think that's right.
That's what we talked about in the beginning, that that's probably where we have to go.
Okay.
But I think it's a great idea.
Worth a shot.
Okay. 203.47, it deals with, that deals with purchase agreement in specific, work for some, licensees in the field. Yes, we have this requirement that, when a decedent is transferred, there are certain things that the transferring funeral home should do, along with the receiving funeral home, to make sure that payment is effected for the transferring establishment. And there was a thought that, well, that this is what we're told, okay, that it's kind of open, it's kind of open-ended. Maybe there needed to be a time horizon to kind of close that. And so obviously that this idea, this context is already in rules. So there's some suggestions there, and we'll just get your thoughts on it. Okay, this young lady, then we're coming back to see it, and then there's probably someone online. Yes.
Is there a way that we could add it also would do for county officials? Because like with having a county contract, they don't pay the contracted funeral homes.
Yeah.
Is there a way to add
Yeah.
anyone? Like in anyone that has to pay you if you've done your service?
Let me look at that.
Throw them in there.
Okay, we got your point. We're gonna go to Sid, then to Jason. Yes.
So I just have in here where it says remittance of funds to the transferring funeral home 15 days after transfer. I would like to see it say just the same as it does later on, within 15 days. Do you see that?
Yeah.
It's the second line under highlight. Just before 15, put in the word within.
Okay.
It tightens it up just a little bit. Because you then go on to say that the payments have to be done within 30 days.
Yeah. Okay. Okay, Okay, Jason? Oh, excuse me. Jim Bates. Okay, Jim, what you got?
Yeah, thanks. Yeah, I agree with Sid. Looks like maybe just a typo to put the word within right before the number 15 days.
Okay.
Otherwise, the language says it's got to be done on the 15th day. And then the other point I've got is, from the consumer's perspective is what's the paper trail on this that's required from funeral home 1 to funeral home 2? So if there's a problem with the fees or whatever, does the consumer have a right to have the copy of the statement of goods and services from funeral home 1? And of course they'll get it for funeral home 2, but I just want to make sure that all the everything that happens is there's a paper trail to go back to if necessary.
Well, they should have received a goods and services document from funeral home 1, since they originally were working with funeral home 1, and they had to have talked about price since they're talking about a removal or some other service. So that's that's the first part of your question. The second is the transferring funeral home will either give a letter, a receipt, or a contract to the receiving funeral home for payment, and then that would be attached to the new statement of goods and services to the family in the receiving funeral home.
Okay, so is that a best practice, common practice, or that's required by rule?
I don't think there's a rule that requires any paperwork for transferring money in dollars or any of that, but that would be a best practice, is to have documentation that the transfer was done and everybody signed off on it, and that whatever the monies to be exchanged were done. And I think you could ask almost any funeral director here, they're going to give something to the transferring funeral home, an invoice, a contract, a letter, something that says, the transfer was $650.
Could you put in there when funeral home was making
I've had a
minutes?
I've had a few consumer calls over the years where somebody does first call in the evening at the hospital. Then in the morning, they wake up and realize they shouldn't have called that funeral home 1. And so they ask what to do. I say, hey, find a funeral home 2 that you want to do business with. And I'm not sure that they ever got anything on funeral home number 1. I'm not sure. But anyway, I just want to get a feel from y'all how that usually works.
We passed statute for this.
Yes. Yes.
It's already in statute.
Okay, it's already in statute. It's now.
This came out of our black funeral homes about 4 or 5 years ago.
That's right.
It was a case where funeral home A had made a removal, actually put the body in the casket. Funeral home B was contacted by the family, and funeral home A didn't get paid for the removal, embalming, or the casket from funeral home B. So a representative out of Dallas brought forth legislation that passed, where funeral home B has to collect the money for funeral home A and pay them. If funeral home B does not pay funeral home A, they are held in violation of statute.
And actually that was out of East Texas.
East Texas was laid out of Dallas, because Lomax was the guy I went to mortuary school with, the one that brought forward.
Yeah, brought forward.
But you may well be right that the originating funeral home didn't even have an opportunity yet to give the consumer a general price list.
Right. Oh, okay. Well, thanks, Bill. Thanks for the background on that. Thank you all. So that helps me bolt this down. Thank you.
Okay. And you were just wanting that just background, right?
Yeah, just have a 60-second conversation on this to help jog my memory when I get that next call,
But there should be a paper trail as far as charges. They can't just come up with a charge, because now funeral home B has the case. They're going to charge $500 more for the removal than normal.
Right, yeah, it's a cash advance on B, so they are required to disclose the price from A, just like it was flowers or whatever. And yeah, it's supposed to be in there, so, okay. Got it, thanks.
Gary, did you have something?
Well, I was just gonna say, what we do that because other things fall in the time zone and requirements and pricing and all that. Is that however this is communicated in whatever time period, is that the originating funeral home should use a statement of goods and services with the other funeral home as purchaser. And then that kicks in that it's gotta match your GPL and all that sort of thing. The only caveat is if it's a mortuary service, which I don't think this is addressing that. Because they would have been contacted by the other funeral home. The other thing I wonder is, just to be clear, of the 5 things listed, should number 6 be permits and vital statistic fees? Because if you're going out of state, the originating funeral home is gonna have to handle that. With the exception of a few funeral homes that are licensed. in
Permanent
Oklahoma.
documentation or something.
Yeah.
Okay. Before I go to my investigator, Carissa, are you
Yeah.
still, okay?
Yeah,
Could you?
let
Go
me just, I think, I put in the chat that the funds should be conditioned upon the receipt of the funds and not the transfer of the remains. So I'm gonna suggest that we add a sentence where, it starts with the receiving funeral establishment. To add language that says upon receipt of funds from the customer. To add that, and then it would go on to read, shall make arrangements for the remittance of the funds to the transferring funeral establishment.
What if, you know, B never gets paid?
They took that, I mean, that's happened to me before. You do have to take that risk doing that.
But would funeral home B be responsible for funeral home A's expenses, even though they never get paid by the consumer?
That's a different issue, I guess.
You know it's gonna happen.
Oh,
Yeah.
Yeah, then you got the body hostage thing, maybe get into the mix too.
Now, I think we've all learned that lesson.
Yeah.
Yeah, yeah, yep. Yeah.
Okay. Point taken. You say upon receipt from customer. Okay. Yes, ma'am.
Establishment upon receipt of funds from the customer. Or, but we shouldn't make it, it should be upon receipt of funds, not the transfer of the remains.
Couldn't funeral home A easily tell funeral home, or funeral home B easily just tell funeral home A that they didn't pay and just not pay it? How would they know? How would I know if I was funeral home A, if that family did or didn't pay them?
I mean,
No, right.
we've already established that funeral home B has to pay funeral home A for the initial services. I think this is just tightening down when that payment is gonna take place. And I don't think that it's incumbent upon funeral home A to take the risk if funeral home B's customer doesn't pay them. I still want my money.
Okay. Hey, Chris, are you still there? I think you had a point to make.
Yeah, yes, sir. I was just following up on the same ideas, what if funeral home B says, well, don't just pay me and I'll get paid for what I do, but we're not don't pay for whatever funeral home A did, so I won't forward it over to them. It's it's a mess. And this is just so everybody knows, there's some states, I think it's Alabama, that allows under the law for a funeral home to hold the remains hostage until they get paid, which I think is a horrible idea, even if the law allows for it. But yeah, crazy.
Okay. Ms. Rodriguez, you have a point? Go ahead.
Oh, no, I was just.
No, well, you had a point about the rule. Okay, what was you don't have a point about the rule. Okay. Okay. All righty.
Can we add or or commercial embalming facility? Like not just a funeral established license, but also add a commercial embalming facility, because that can also happen from mortuary service to mortuary.
Funeral home B doesn't want to pay funeral home, or funeral home B has to pay funeral home A, but funeral home A uses commercial embalming service. Can you put wording in there to where funeral home B has to pay the commercial embalming service instead of funeral home A, whoever the bill's with? Whoever did the work? Cause right now, I'm constantly getting told, and I'm having.
Just add in parentheses our commercial mortuary service.
I was trying to see if they were included in the statutory definition as well, just double checking, they're not.
It would.
It needs to be like, because it's a different type of license,
Right,
a commercial embalming.
Could you explain that scenario?
So whenever I make a removal for funeral home A, and they lose the body to funeral home B, funeral home A wants funeral home B to pay my charge. But funeral home B doesn't want to, because it says in the statutes that whoever gives direction is in charge of that bill. So funeral home B refuses to pay embalming service for said work because funeral home A called them.
But it says whoever makes the call is responsible for the charge.
Okay.
So I'm doing a lot of work where this funeral home has lost it to this funeral home refuses to pay my bill because they didn't call it. And under the law right now, they're ever right, they don't have to. So then I have to go to funeral home A, and funeral home A's not getting paid by the family, but yet I'm making them pay my bill because they called me. It's just a big mess.
And then they're mad.
And then everybody's mad at me.
Okay, Norma?
Sorry about that. So I do think when funeral home A is transferring to B, an invoice should be provided so that B can explain where these charges are coming from. And I'm not hearing that that's always included. So that would be helpful.
Well, that is best practice now, is either by whipping out a funeral services contract for, and having it in there, or a letterhead invoice that says, okay,
Explaining the charges.
this is where the charges.
People have to disclose that.
Yeah, and a statement of goods and services, I'm called because you're also disclosing why the embalming was done, if it's embalming and other things.
Right, but generally, the transfer happens before it.
Yeah, because they'll call you at 3 AM, you go do the first call, and then next day they're like, oh, Aunt Sally said we have to go here.
Right.
And then, you haven't met with me yet. So you have to say, oh, well, that was $500.
But there should be, there should be paperwork from funeral home A to funeral home B.
I don't talk to the family and I'm sending to another funeral home in any reason, whether because of a screw up or we know we're going to bury in New York and we just do this. I make out, and the funeral home knows it, I make out a statement of goods and services where that other funeral home is the purchaser.
That's what I do.
And then it goes, and if there's any legal recourse, whether state, city, whatever, because if they're in Texas and they screw you, he's gonna come to my aid. Okay, I already know that. But if they're in Georgia, I'm out of luck.
So real quick, because I know you're saying that was best practices, but Commissioner, you were saying it's a FTC rule.
Well, when she was talking about giving them
Requirement.
what
An
they've
invoice.
spent, like an invoice of some kind.
Okay, so maybe we just need to
Disclosure of
incorporate that
costs is
reference, so that we need some state.
Yeah, that's under the funeral rule.
I think we got.
But that's for funeral home B, not for funeral home A.
Not technically, they're a licensed funeral establishment, they need to disclose their prices.
Who's your client? If funeral home B is calling you, it's not the family.
Right.
It's the.
I would deal with the family, and because they need to sign my release document for me to release the remains to funeral home B.
Okay, I see, I see Tim. Who's got their hand up? Tim?
Yeah, that's me, Tim Brown here.
Oh, Commissioner, okay, we wanted to, okay, good to,
So
good to see you, sir.
going back to this, my assumption is that my assumption is that funeral home A would, they would, is he out?
No, go ahead.
Okay,
Commissioner.
my assumption is that funeral home A would continue, to bill funeral home B as they normally would. And then funeral home A is responsible for paying the mortuary service or the embalming establishment. I don't see why that would change. It's still funeral home A's responsibility, and funeral home A is covered by this statute that we're writing, that they're going to be paid by funeral home B.
Maybe we just need it in black and white. That's not written.
All right, see, and we got another hand up. Is that still Tim? Okay, all right. Okay, so we got some tune up on that one. All right. This one here, House Bill 4123. Yeah. Right. This one here, it's new legislation. Let me just give you the background. There was some federal activity on criminal records, and it triggered licensing agencies, not just for Texas, but throughout the country, to tighten up their statute as far as who they're requiring criminal records from, how those records are treated and dealt with, disposed of in the particular agency. And so we all had to redo that, pharmacy, medical board, etc. Louisiana, Texas, New Mexico, etc. Okay. Now, so with that, the legislative opportunity was from the funeral service, particularly for the Funeral Services Commission, was the issue with funeral establishment owners, not having to be subject to a criminal background check, and prospective employees, okay, of the agency. And so we were able to incorporate that. Specifically, as it relates to owners. Okay. We just wanted to get your, because you have different type of owners, right, Sid? You may have owners of, several 100,000 shareholders, or it may be a partnership of a few folks, okay? Or it could be a sole proprietor, okay? You can think of all the permutations of ownership. And so just wanted to get your feel on especially owners. Yes, sir.
I'm a little confused, but it's a very long document.
Yes.
And it encompasses a vast net of unsuspecting people. And so we're in there somewhere, because there's a whole list of people in one section, and it says Texas Funeral Service Commission. Right. But I couldn't figure out what the rules were just for us.
Well, yeah, so that's the statute. So in rule,
okay,
I want to become a funeral director. I want to become an embalmer, and/or I'm gonna subject myself to a criminal background check.
Yes.
Got it. Okay. Now, I really don't want to be a funeral director. For example, I really don't want to be a funeral director. I really don't want to be an embalmer, but I want to own a funeral establishment. Okay.
A non-licensed owner.
Exactly.
Okay.
All right. So there's nothing in statute right now, except for crematories, I believe. But there's nothing in statute now that says when that new establishment application comes in for Mr. Bass to work with licensing and say, send this prospective owner who's unlicensed criminal background check instructions.
Right.
Okay, there's nothing there. So as one of my investigators, I believe Ms. Rodriguez would say, is if I'm the owner and I'm probably cutting the check, you know, I got just as much access to sensitive information. And plus I'm signing the front of the check, and funeral directors see it, you know, you like working here, don't you? We know what you're supposed to do as a licensee, but you know, you like working here, don't you? You like working for me? Well, I just need you to go do this. Okay, now, obviously, we're hoping, and we know Sid would say, well, I'm not doing this. I'm a licensee and this is, you know, against the rules, against the statute. But you see where I'm going. Okay.
I actually worked for a non-licensed owner of a funeral home.
Okay.
And I was the FDIC. And I said to him, you may cut my check, but I interpret the rules.
Okay.
And we agreed to that. And we agreed to that, or I wasn't gonna be there because he had no license.
Okay.
I had the license and I was subject to suspension, revocation, etc. So that I understand what you're saying, and I think Jake Carnes, I don't know if he's still on the call or not, but he would definitely agree with me that not only should they be subject to background checks, but they also should be subject to insurance information. In other words, they should be insured before they can be an owner. It shows that they have financial commitment to the business.
Okay.
Well, that was a legislative change. When we had that conversation last time, we don't have the rulemaking authority on that, on the insurance part.
We don't.
We don't.
Okay, so then then we're SOL on that one. But what about background checks? Can we enforce that?
Well,
oh no, go ahead. I don't have anything. I was about to ask you.
Okay. Well, according to what's in the statute now, we included owners. And we've included prospective employees of the commission.
Good. So
Yes, sir.
I'm looking at 651, 657, and I think you, well, that's a crematory.
Yes, just for crematory.
So would a potential owner have to go through the same procedures that a licensee would have to go through for background disclosures?
That's the point. So
And then the commission would either grant or reject their application
For establishment.
for an establishment?
yes, it would just be like for our licensees, and to the extent that there are previous criminal activity or offenses that are related to the practice of funeral directing and embalming, and those are in 203.16, I believe, in the rule, then if that's the case, they would go through that process of going through the commission to evaluate.
And then that would stop people from circumventing just hiring out a license.
So the new statute expressly says that a person who is a holder of a license or certificate under chapter 651 occupations code, which will include establishment owners, not just individual licensees, is subject to the criminal background check, as well as a person authorized to access vital records, so that, or the vital records electronic system housed by dishes. So that also means any employee that has access to dishes, they also have to, or to get death certificates, they also have to undergo a criminal background check.
And they actually fingerprint. They have to get fingerprints. Yep. So the funeral directors don't have to do that because we already did that when we became funeral directors.
Yes, and you're in what we call our subscription. So if something comes up, we're one of the first ones that are notified if something comes up.
And I think that's pursuant though to a cross-agency memorandum of agreement. If that didn't exist.
Yeah.
It's still.
Absolutely.
I think it's a great idea.
Okay. Yeah.
Because then you have a good feeling, the commission has a good feeling of an owner's at least knowing that they're clean as it relates to funeral industry issues, that they're clean in order to own a funeral home.
Or I got a record, I know I can't be a licensee, so I'll just loop around and own the facility.
What are you gonna do about those now that are owners?
I was waiting for that one.
Yeah.
Let's get them.
Throwing the names in the hat or what?
Well, they have to renew the license.
That's right.
So that's part of the license renewal.
Yeah. Ms. Haynes, when someone renews a license for an establishment, in that application, they do ask about criminal history, right? Right now.
Right now, yes.
I think I've seen that before, yes.
But it's in, questions are like, have you had any administrative code? Has the commission put any penalties on you? So it's more as the.
Administrative.
Right, administrative, not so much as criminal.
Related to just that establishment
Related to
license,
just that
not a
establishment.
person, not a
Right,
human.
right.
Right. Because some of them are owned by a corporation.
Right.
And I know that's, I think something we were gonna explore too.
Yes. Yeah. You know, models out there where pharmacy industry, top 5
Department of
officers, yeah, it's top 5 officers or something like that.
Well, right now, the crematory application only requires the information for each shareholder who owns more than 25% of the corporate stock, and each officer or director of the business, if the business is a corporation, and then each partner if the business is a partnership, and the applicant if it's owned as an individual. That seems like something you could repeat.
And are we doing?
Yes.
Yeah, because it's adjacent to the business that it's.
That's right. Because it's adjacent.
So we're
to the
not,
Same corporation, or it has to be the exact same owner. That the crematory is adjacent to, like yours.
right, so are we doing this currently with crematory? Getting the background checks and all of that?
Oh,
No, it just doesn't require us to do a background check. The statute just says they're required to detail for each individual named under that subdivision, the ones I just named, any felony or misdemeanor conviction of the individual.
No one's.
Or any,
the owner?
yeah, of, yes.
25%.
25% owner, officer, director, member, or the board of directors, partner or applicant. They have to self-disclose that in the application. Whether they have, details or business experience previous 10 years, any felony or misdemeanor conviction of the individual, any involvement of the individual as a defendant in a civil action involving allegations of fraud, and any suspension by the state or other state of any license related to funeral directing or the operation of a cemetery or crematory.
If that's from Department of Banking, that's exactly what's required for cemeterians.
Cemetery.
And that was where that's where the.
Ethical people would answer
cremation
those,
was.
unethical would just lie.
Okay.
Well, I mean, they submit to the background check. You should have that, like, where you have permission.
Okay, so.
And I guess admission, yeah, and you said this also mentions the staff in here.
It would follow that we can verify the information on the application. I would think so.
So those that are now that never done this, did you say you're going to start doing this when the renewal time comes up?
I don't know if I said anything yet, but okay. I know this question maybe came up sometime earlier of this year, okay? So, obviously a renewal, some would say, let me just say this, I don't want to be so definitive. Some would say, when I renew, I'm filling out an application for my establishment or my license, okay? And therefore, I get caught up in this, some would say dragnet. I think that's an old movie, TV series. I get caught up in this dragnet. I think over the next few days, we will be a little bit more prescriptive on that. Chet.
I mean, there is no limitation for the holder of a certificate or license under chapter 651, or for a person authorized to access vital, whereas the others say specifically an applicant. So I think we're given a little bit more broad discretion.
I like that.
Well, if that's gonna come about, and once the rule has been published and becomes effective, then for funeral establishment renewals, I think advance notice of background checks, mandatory background checks for ownership, as was described in the same way crematories were, for instance, that you just need more time in order to do that.
So from a, we're getting into a practical aspect of this. So let's say James is I don't have any criminal history, but I've been an owner for a while. Okay, now I got to go down and do the background check. I go do the background check, and now we find out you have something. Then I think the question then would become, would we be under any
Follow our typical criminal history, like
we would follow that in there. Okay, so yes, we would have a way to really land this plane, and it wouldn't probably be after the rule is promulgated. All y'all go out and get right now. Maybe it's tiered based on
whether it's related to the business
funeral director. So maybe it's tiered to when you come up for your renewal, then you have to go out and get that.
Yeah, no, that's what I'm saying is that as the funeral home, we're talking about funeral home establishments. So they come due every year. So mine is due in, I think, August or September. We'll say August. Okay, so you usually notify me, we'll say in July, that my renewal is going to be due. But maybe now not July, but in June, you tell me in July or in August, your renewal is going to come due. And starting this year, you're going to need a background check. So please be aware, it may take longer to get your renewal than.
Well, we think what'll happen is the renewal, the background check usually comes back to us relatively soon, 4 or 5 days. Okay,
but I could renew my license on the last day of the month that it's due, post up the fact that I paid for the renewal and wait for my license. Now you're adding a whole extra piece in there, a background check, and if the time expires and you don't get the license, you're no longer a funeral home, you no longer can serve the consumers of the state of Texas. There's a lot more issues there. And so I'm just saying that if we're gonna do this, we gotta give owners that are not otherwise licensed notice, and plenty of notice.
Got it. Okay.
Because the way they do business is going to change.
Okay.
I mean, it's kind of like what we did for the anatomical. So, and we'll probably, I mean, I'm sure too, we're gonna have to make sure it's practical and how we implement it so that, because I mean, the goal is to help y'all keep business operating as usual. So just, we'll make sure it's common sense.
Homes, it's established.
Right.
Crematories,
Right.
embalming established.
Well, crematories are already, are already in there.
They're already licensed.
But there is.
Wrap it up in the whole, yeah.
Yes, wrap it up.
Yeah.
Okay, there is one, there was one other suggestion that didn't come up necessarily in, this summer. It's the last one, and I put it as the last one for a reason. That dealt with, at least a temporary license that you can print off until you get the hard copy, card stock blue license. We're not going to deal with that because Maria and I have been talking, and there's some quirk we need to work out with our IT folks. So I don't want to consume your time with something that may take another 6 months to fix, and we'll just come back to you if we decide that we need to do that. And so that kind of wraps up our business for the day. Before we leave, I want to give our commissioners an opportunity to tell you goodbye, but if I could just do some announcements about some future calendar things. Okay, one, November the 30th at 10 a.m. November the 30th at 10 a.m. We'll have the first state anatomical advisory committee meeting. That'll be November the 30th at 10 a.m. It'll be from 10 to 12. It'll be a very short meeting. And what we'll do in that meeting, we will, the committee will elect their presiding officer. I will give them their initial charge, which is advising the commission on the future rules in that policy space. And we'll give them a primer orientation on SB 2040 and rulemaking. So that'll be November the 30th, 10 a.m. It will be both here and on Zoom because it's just 2 hours. So we have members on that committee. Well, we have members and licensees now that are East Texas, West Texas. So for 2 hours, we just don't want to.
Yeah. In this room here.
I believe it is going to be this one. It's going to be this room here. Okay. And then December the 11th. What time are we starting? 9:30?
9. It says 9 on the calendar.
Okay. December the 11th at 9.
For just commissioners though, and the actual meeting started.
Well, let's do this. We haven't posted yet. So let's make it 9:30. Okay, so 9:30.
It's a much pleasanter time to.
9:30, December the 11th will be the fourth quarter
In this.
commission meeting.
It says
Is it in this room?
And we're gonna do it here. Okay, right. Okay, and we'll do it here as well.
And it'll also be Zoom.
We'll have, for the commissioners, the expectation is they'll be here physically, but we will have Zoom
For the public.
for the public. But public comment will only be open during public comment. So, like we've been doing here, great folks weighing in, that's okay for this, but once that public comment period closes, everybody turns into, at least out there, obviously, the viewers, okay, only. Okay, so I just wanted to get those two out. There will be a few more of the State Anatomical Advisory Committee meetings over the next few months, and we'll get those to you, but I just wanted to say that. And so I will turn it over to our commissioners for any parting comments.
Well, thank you all for being here and for your input. We know your time is valuable and we value all of your comments, and it means a great deal to us. And if you don't tell us something's broken, we can't fix it. So we're glad that you're here and thank you for your input.
I really don't have anything to add. Thank you so much, though, for being a part of this process. I think at least this is the first time I've been through this process since I've been on the commission. We haven't really undertaken it in this scope in a long time, I think, and
your viewers too.
And the viewers too. I know people have been popping on and off throughout the day, and hopefully this worked for y'all so that we can hear from people out in the field without having to leave your businesses or your homes and other things. So Thank you again to everyone who participated in this.
In behalf of the staff, thank you so much. This has been extremely helpful for us. It's been extremely helpful for legal inspections, enforcement, licensing. Obviously, our new staff attorney to sit here and listen to you, and it gives us context on how to continue to help you out. Thank you so much. Thank you.
Choice of words, undertaking.